two market, two gate.
Yes, what is this?
This is a settlement of one Ditokchara gate. Ditokchara gate, where, I mean, they have shown that Mandar.
Oh, I have asked them to give us the details.
But in Mandardesa gate, my lord, they have settled it for 5 crore some amount. And the condition is that to settle, to deposit the amount at the time of taking the order. They have not settled, they could not deposit the amount 5 crore something, they have deposited 2 crore something. Therefore, the second he has filed a writ petition. So that writ petition for the purpose of the statement is there.
We'll see when the matter is called.
Yes. Can I call for the case record of, because one lead petition was filed saying the second highest bidder, then please settle it to us because these are not.
We'll see when we'll pass an order, not now. Like,
I would like to mention one case, my lord, for listing, my lord. My lord, urgency is this, my lord, since,
motion,
my lord.
motion,
No, my lord, for admission, hearing. Any day, my lord, in the next week.
motion, admission.
Admission.
Why?
My lord, what happens in this case, petitioner is the settlement holder of a mall, Sand and Stain Mall, for a period of 7 years. My lord, after expiry of 5 years on May 2024, the renewal of environmental clearance is necessary. That was already applied for. That has not been granted. And the DFO went on receiving the KIST money, but did not allow us to operate the mall till date, my lord. That is why before this honorable court. My lord. So, if
Let's
it is
have it on-
possible in the next 5 days, possible, my lord.
Okay, let's have it on 7th.
My lord.
7th of November.
Obliged.
We have opted for listing of the matter on Monday, my lord.
Why?
Regarding my lord, not issuance
Motion.
motion matter. I know.
Made Lordship, I beg, with the consent of the other side, I beg to mention item number 36.
16.
36, Lordship.
36.
In this matter, Mr. B. Chaudhary is appearing on the behalf of Agriculture Department. His mother is unwell, Lordship. So he has to rush with her to the doctor, Lordship. Kindly accommodate
Item
for the
matter
day.
has come up for orders. You are there.
Orders,
My lord.
We'll see where the matter has come up for orders. We'll accommodate. Don't worry. Nothing here will be done, but we'll see what orders are required.
Lordship.
Maybe the service is not complete.
Lordship.
May have happened because if I adjourn it, the matter remains like this. So for admission, it's a different aspect. We'll take it up when the matter reaches.
Lordship.
May it please, Lordship, I beg to mention for calling an additional affidavit file today for item number 34.
For Joel, item 32.
Yes, what is this?
My lord, this is regarding, my lord, the arm license, my lord, renewal of my arm license. I filed this writ petition praying for a direction to the respondents, my lord, to renew my arm license, but my lord, during the pendency, my lord, they have rejected it, my lord. They have rejected it.
So you have to challenge
Yes,
that.
my lord, I have to challenge the order.
Mr. R.M. Dekal, Learned Counsel appearing on behalf of the petitioner submits that the instant writ petition was filed seeking appropriate directions for renewal of the arm license. However, during the pendency of the instant writ petition, the respondents have rejected the said application and resultantly, it would now be necessary on the part, the petitioner herein would now have to challenge such rejection. He therefore submits that the instant writ petition had become infructuous.
Right.
Accordingly, the instant writ petition stands closed. It is observed that the closure of the instant writ petition shall not affect the rights to challenge the rejection of the
Right.
application seeking renewal of the arm license.
Deeply obliged.
For motion item 1.
May I please, Lordship? Lordship, kindly after some time, Lordship, senior
What?
and legs. After some time, Lordship, senior
Why?
and legs. Lordship, he has some surgery in.
This is item number 1.
Yes, Lordship, he has some surgery, Lordship. That's why he has gone for dressing. He will come, Lordship.
Okay. You start. By the time he will come, na? You start slowly. We'll see what is your map.
Lordship, it is for Lordship, as there was an IMFL Lordship license was issued, Lordship, where later on it was cancelled. Lordship, my senior will be better in this position to submit, Lordship.
No, you submit. We'll help you out. Then only you can wage your cancellation order.
Lordship, it is in page number 1.
Yes, Mr. Gogoi. Where is the cancellation order?
Cancellation order, page 133. I'm sorry, my lord.
Yes.
Page 133 is the cancellation order. Impure order is at page 133, my lord. Now, my lord, here they are saying that the chairperson of Dhakiajoli Municipal Board have sent a letter saying that they have not issued any NOC.
So they have rejected it on the ground that you have submitted a forged NOC.
NOC.
So you say it is not forged.
I have applied as per due process. I have received, I have submitted. Now, my lord, whatever may be the allegations, the principle of national justice says that I should have been awarded an opportunity of being heard. No notice have been issued to me. Simply it is cancelled. One notice was there asking me to produce the certificate. I produced. Subsequently,
Where is that notice?
kindly come to, my lord, page 132. Only this is what I have received, my lord.
There's a page 131.
Type copy, my lord.
This office, under the direction of the district, is investigating as alleged forged signature on a no objections issued in your name, purportedly signed. The chairman has denied signing the document necessitating a thorough inquiry. To ascertain the facts, you are requested to appear in person at the office of the undersigned on Wednesday. Your statement is crucial to understand how the NOC was obtained, who provided it to you, and its intended purpose. You are requested to bring the original NOC along with so-and-so. Then
I went there, my lord, with all documents. I submitted everything. Now, my lord, what I understand, kindly see, my lord, for a moment, page 133, first 2 lines. Whereas complaint petition submitted by chairperson, Dhakiajoli Municipal Board, white letter number so-and-so dated 26/3/2025, against the IMFL off-shop license, namely ABD wine shop license, Sri Dev Kumar Gope, mentioning that no objection certificate submitted by Sri Dev Kumar Gope was forged. So what I understand, my lord, on 26/3/2025, the district commissioner Sonitpur Tezpur received a complaint. Then he have initiated an inquiry. Then, my lord, after 26/3/2025, now kindly come to page 132. On 6/6/2025, the Assistant Commissioner Dhakiajoli Co-District says that, dear sir, this office under the direction of District Commissioner is investigating an LS4 signature on NOC. Now, my lord, what I understand is that the letter mentioned in the first para of the cancellation order, as per that letter, the inquiry was being conducted by the Assistant Commissioner, Dhakiajoli. I have participated in that inquiry. Now, my lord, without taking into consideration that inquiry report, this cancellation order has been passed, my lord. In the cancellation order, there is no mention about the inquiry. Simply 2 things are mentioned in the cancellation order, my lord. First is that there is a complaint by the chairperson, and second is that there is an FIR by the executive officer. If an inquiry was initiated to find out the facts, then, my lord, that inquiry report should have been considered. Maybe that inquiry is not complete. If
what
without
has happened to
completion,
the FIR?
my lord,
FIR, what is that?
My lord, kindly come to page number
I,
124.
no, I've read it. What has happened? You know about the FIR.
My lord, we came to know about the FIR from this notice, from the cancellation order. Thereafter, through online, we have found a case number, and then we have applied the certified copy. Till today, police have not called the petitioner up to the police station for investigation.
And what is your letter which you have written on 128?
128, my lord. Yes, sir.
And
Yes, my lord, I have requested to allow me to open the shop.
And what is the letter on 14.2?
14 my lord. 122 page number.
You have not stated that you have issued the license, NOC in 128.
128, my lord.
Because the allegation has been made by the Dekhiajali board categorically on you on 14/2/2025 that you have opened up a shop without the NOC. This is done on 14/2. This is followed by an FIR filed on 21/2. You reply on 21/2, 27/2 that you have got the license here, but there is no allegation that you have not stated that you have got the NOC with properly. Where is your statement? In page 128.
My lord, all throughout, my lord, nobody have written me any letter.
And you have replied to this at page 128. Why are you saying that no letter has been written?
120, I have kept my excise shop closed ever since you issued the
No,
above.
no, kindly see the reference. Reference your letter dated so and so dated 14/2/2025 at page 128.
14 to letter to
Page number 120.
My lord, here she is saying that it is hereby in 14 to what was communicated to me was
That there is no NOC issue.
there is no NOC issue.
Where have you mentioned in this communication to the chairman that you have issued the NOC? So you knew it. What is wrong? And why,
No.
isn't that a
No, my
clear
lord.
provision available against cancellation?
Cancellation, there is a time frame. Within 30 days, they have to approach this revenue board, your lordship.
Go before the revenue.
My
board.
lord,
Why should we look into these disputed questions of facts?
no, my lord,
There's no natural justice violation.
My-
You were invited out there, you were asked for the inquiry, you have gone out there and thereupon nothing happened.
No.
No violation.
my lord, after 14 to my lord,
No, no.
kindly
no,
see,
no
kindly see
case.
page 121.
No case, bad case.
I'm just answering to your
Luckily
lordship.
you came over.
No, lordship,
Before your junior, I got this matter discussed.
no, lordship, I'm just answering to lordship's
Okay.
query. Or after 14 to, when that allegation was there, kindly see page 121 for a moment, my lord. 121, my lord.
Yes.
Kindly see, my lord. To chairman Dekhiajali board, municipal board, page 121, my lord.
Yes.
Submission of documents asked by you via letter number 14 to 2025. Dear madam, respectfully reference to the subject cited above, I would like to inform you that I am submitting under mentioned Xerox documents related to ABT wine shop. Now, my lord, kindly see serial number 6 NOC copy. I have submitted immediately after 14 to.
Where?
Serial number 6,
This
my
is
lord.
not in reference to 14/2.
14 to, my lord.
No.
20.
Where is it mentioned 14?
My lord, it is mentioned subject, my lord.
Where?
Submission of
Read it.
documents asked by you, white, so and so, 14 to
Then? This is Mr. Khan, you may not know, not read the facts properly. This document is in reference to another document, 2533. And the reference of 14/2 is 2545. That case is dismissal with
no,
cause.
my lord,
Dismissed with cause.
there did, my
No
lord,
FIR,
my lord, there is an allegation, my lord, against me, my lord.
serious allegation against
But
you.
no inquiry was conducted, my lord.
Inquiry conducted.
No, my lord.
You appeared.
My
You
lord,
appeared
if
before them.
this is the inquiry, my lord,
Huh?
suppose page 132 is the inquiry, my lord.
Yes,
132, my lord.
yes.
Inquiry was being conducted by Assistant Commissioner Dekhiajali, my lord.
Ah,
Under the instruction of the District Commissioner Sonitpur,
yes,
who have cancelled my license, my lord.
yes.
I appeared in this inquiry, my lord. I submitted all my documents. Thereafter, I do not know what happened with the inquiry.
No,
The
that is the-
conclusion is not out, my
there is
lord.
no further inquiry required.
My lord, may I submit in this
Go
manner, my lord?
Go before the Board of Review.
The inquiry report is not mentioned in the cancellation order, my
Not
lord.
necessary. Not necessary. You, on that day, they categorically say on 14/2 to you that you have no NOC. You have not replied out there that yes, there is a proper NOC, you have issued it. Your reply does not say so. They found out when they used that letter ending with 3/3. Huh? Dismissed.
No, my lord,
And you have taken more time.
no, my lord, after
Yeah.
cancellation also, my lord, I have raised the issue
No.
that
No.
I had obtained the NOC with due
Only,
process,
Mr.
page
Khan, I
134.
can only permit you only one thing. Go before the tribunal. That's all, without discussioning anything. Otherwise, I dismiss it right away. It's a case of, they are saying it's a forced document. Matter ends. And they have duly informed you, asked you to come. You have gone out there, visited. You have not submitted your reply. That is your lookout.
Now, my lord, that is also one thing, my lord.
No,
They are not, it's not false, it is saying doubtful. Doubtful, my lord.
they have made inquiry and found out nothing. How
That-
can this court decide?
My
Now,
lord-
how on earth can this court decide this aspect?
My-
Whether the NOC is false or not, they have categorically filed an FIR. They have also informed you about that there is no NOC issue.
My lord, they have filed an FIR, that is true, but till today I am not called for investigation. That also I am making a submission before
So
this
what?
court. And my lord, they have,
Very good. Investigation
they-
has not been called for.
an inquiry was
But they
conducted,
have-
my lord.
They have not issued the NOC. There is the categorical statement.
May I make the submission, my lord?
No,
That if there an inquiry was ordered, my lord, inquiry was directed, my lord, then my lord, the cancellation order, my lord, should have be based amongst others, my lord, on the inquiry report. Otherwise, this inquiry is of no use. My lord, on the one hand, they are saying we have conducted inquiry, so principle of natural justice is followed. On the other hand, on the cancellation order, they are not making any mention about the inquiry report, what came out in the inquiry report, my lord. There is nothing in the cancellation order, my lord, may kindly consider that, my lord. Because there is an inquiry. I have the only inquiry which I have participated, if at all principles of natural justice is followed, is the letter is 6/6/2025. That is page 132.
so we dismiss it. No, not going anywhere. Finished. Heard Mr. F. Khan, the learned counsel appearing on behalf of the petitioner, Mr. R.R. Gogoi appears on behalf of the respondent. The petitioner herein has approached this court challenging an order dated 4/7/2025 passed by the District Commissioner Punitpur, thereby cancelling the license of IMFL off license, thereby cancelling the IMFL off shop license issued to the petitioner in the name of ABD Wine Shop in terms with Rule 30 bracket 1 brackets capital C of the Assam Excise Rules 2016, for short, the rules of 2016. Full stop. Bereft of unnecessary details, it is relevant to take note of that the petitioner was issued a license bearing number, IMFL off license bearing number 19/2024-25. On the basis of various documents, including an NOC, no objection certificate issued by the Dhekiajuli Municipal Board, by the chairman, Dhekiajuli Municipal Board. First, the materials on record reveal that on 7/2/2025, the chairman of Dhekiajuli Municipal Board issued a license to the petitioner. Issued the communication to the petitioner. Stating inter alia that an IMFL shop in the name of ABD have been had been noticed in ward number 5 by the National Highway number 15. For the purpose of opening an IMFL shop, comma, a no objection certificate issued by the municipal board was required. And there was no such certificate has been issued in respect of ABD IMFL shop. The petitioner was therefore asked to submit the no objection certificate along with other relevant documents before 10/2/2025 in the office of the municipal board. In pursuance to the said communication dated 7/2/2025, the petitioner submitted the various documents, including the NOC by the communication dated 18/2/2025. It is also seen that on 14/2/2025, the petitioner was informed by the chairman of the Dhekiajodi Municipal Board that as the IMFL off shop have been opened in the name of ABD without taking any NOC, the petitioner was asked to close down the one shop. It is also relevant to take note of that on 21/2/2025, the executive officer of the Dhekiajodi Municipal Board had also lodged an FIR which was registered and numbered as Dhekiajodi PS case number 49/2025 under sections 336 bracket 3/340 bracket 2 of the Bharatiya Nyaya Sanhita. The record further reveals that the petitioner submitted a reply on 27/2/2025 to the chairman Dhekiajodi Municipal Board, wherein there is not a single whisper that the petitioner have obtained a NOC from the chairman of Dhekiajodi Municipal Board. It is further seen that in pursuance to all these complaints, the Assistant Commissioner, Dhekiajodi Municipal Board, Dhekiajodi Co-District, have issued a notice to the petitioner requesting him to appear in the inquiry regarding the NOC with the alleged forged signature. The time was fixed on 10/6/2025 for the petitioner to appear at 1 p.m. And the petitioner was asked to bring the original NOC, any related document, bracket, example, e.g., application forms, receipts, bracket close, and identification proof. The petitioner admittedly participated in the said inquiry proceedings, and thereupon the impugn order was passed on 4/7/2025, holding inter alia that from the said inquiry it was found that the petitioner's license, it was found that the no objection certificate which was submitted by the petitioner was a forged document, and accordingly, in terms with Rule 30 bracket 1 bracket capital C of the rules of 2016, the petitioner's IMFL off license was cancelled. It is under such circumstances the present petitioner is before this court. the petitioner is before this court. The learned counsel appearing on behalf of the petitioner submitted that there has been failure of the principles of natural justice on the ground that the petitioner was not intimated as regards the inquiry report.
And that the cancellation is not based on the inquiry report.
And further, the cancellation under no circumstance, cancellation by the impugned order under no circumstances can be said being based upon the inquiry report. Par contra, Mr. R.R. Gogoi, appearing on behalf of the Excise Department, submitted that the petitioner have approached this court seeking equitable jurisdiction, basing his claim on the basis of a fraudulent document. He further submitted that the petitioner was duly provided due opportunity to explain, and after taking into account the said explanation, the impugned order was passed. Isn't it? Anything more?
No.
This court, having heard the learned counsels and having perused the materials on record, do not find that the petitioner have placed materials before the respondent authority, that the NOC which have been issued by the chairman on the basis of which the petitioner had obtained the IMFL license is a proper document and not a false or a fraudulent document. In fact, while replying to the communication dated 14/2/2025 of the chairman of the Dhekiajuli Municipal Board, via the communication dated 27/2/2025 by the petitioner, there's not a single whisper that the NOC which have been issued by the chairman of the municipal board was a proper have been issued in accord properly. Under such circumstances, as the question arises in the instant proceeding, the question which have been agitated in the instant proceedings is nothing to do as regards the violation of principles of natural justice, inasmuch as the petitioner have been duly given the opportunity to explain by the communication dated 6/6/2025, and the petitioner had duly participated in the said inquiry proceedings. It is the opinion of this court that unless there are strong evidence to show that the NOC which have been issued by the NOC on the basis of which the petitioner claimed had sought for the IMFL off license have been issued properly. The question of interference by this court, writ court, under Article 2 to 6 of the Constitution does not arise. So, under such circumstances, this court does not find good grounds for interfering, for even entertaining the instant writ petition by issuance of notice. Consequently, the writ petition stands dismissed.
Item 2.
Obligement.
Yes, Mr. Sikdar, what is this?
My lord, the petitioner is seeking certified copy of voter list of 1971.
List.
As far as this matter is concerned, we need some time for taking next steps.
What one? The voter.
My lord, no, he's not the voter, but 71 voter list is seeking for certified copy.
Huh?
In 71 voter list, his grandfather's name is there. So
What
that
is your-
voter list needs
what
a
is one here?
my lord. And we have applied, that was acknowledged, my lord, Annexure 9.
Shall not be directly. No, we can pass a direction to provide the certified copy of the voters list of village so and so under 53 number Horuhetri.
Yes.
And you have to have a particular area. You cannot have the whole voters list
My lord,
of 53 Horuhetri LLC. You will require for the particular area.
my lord, yes, my lord.
Which one do you want?
71 voter list, annexer 2.
Understood. The earlier voters list is where?
My lord, earlier,
56 is for 53 is, there's a particular condo and all these things are there, na?
my lord. The vernacular portion at page 15, annexer 2,
Condo number is 133.
condo number
Condo fee
133.
is
my lord.
53. So we are concerned with
Only-
133.
Only, my lord, this, my lord, voter
Which
list.
one do you want?
71 voter list at page.
Page? Why you are asking for certified copy? You must be having a photocopy,
Yes, we have photocopy. That
Which
is
one?
annexer 15.
huh?
Annexer at page 15.
15. Okay, you
Your
want a
grandfather's
certified
name is
copy of
Kos-
this.
Yes, my lord.
That's it. Look, why you're not giving? Give it to him. He wants a certified copy. He's not asking you anything more than that. He'll pay his dues.
Give us some sort in my lord. We shall issue the same,
Huh?
2 or 3 days maybe given my lord.
You are going to bring it before the court. Okay.
My lord, the petitioner may also avail the certified copy in the CSC center of the concerned department.
We have
They are asking,
applied.
they are seeking some time, some sort
So give them certified copy.
Yes.
You are paying for whom?
for respondent number 1, 2, and 4.
1, 2, and 4. You are appearing, you are not the standing counsel of the election department.
It's on leave, my lord.
Who?
I leave, sorry.
Yes, Miss P. Borua. Come over. You have no business out here. I don't ask.
Yes, Your Lordship.
He is asking, you are also a standing counsel of the
Yes, Your
Election Commission of India. Here is a case where he is asking for a certified copy. What is your problem in giving the certified copy? He will pay his dues. Give him the certified copy. Matter ends there.
71 voter list, 71 voter list. 8 was certified.
Simple case.
Apply with me.
Your Lordship, actually, I do not know, I have not received this file, but Your Lordship, I can.
I also don't require the file. I have also not read the file. The first thing I have seen out there, he is asking for a certified copy. What heavens will fall upon you if you give a certified copy? You are not saying, I'm not asking you to put his name in the certified copy and give it to him. He wants a certified copy of this particular condo,
My lord.
condo 133.
We will arrange, Your Lordship.
Yes, my lord.
Okay?
We will arrange, Your Lordship.
Okay. Heard Mr. A.R. Sikdar, the learned counsel appearing on behalf of the petitioner. Ms. P. Borua appears on behalf of the Election Commission of India. And Mr. B. Bokel appears on behalf of the state of Assam. The petitioner herein is aggrieved by has approached this court being aggrieved at the non-issuance of the certified copy of the voters list of village Ukarpara,
Ukar Par.
Kaukarpa under 53 number Horuhetri LAC of Borpeta district. Pertaining to condo number 133. This court inquired with Ms. P. Borua, the learned standing counsel of the Election Commission of India, as well as appearing on behalf of the respondent number 2 and 4. Appearing on behalf of the respondent number 1, 2, and 4 as to why the certified copy of the voters list as sought for by the petitioner cannot be issued to him, taking into account that the voters list is a public document. Ms. P. Borua, the learned standing counsel, submits that the respondent should not have any objection in providing the certified copy. Considering the above, this court directs the this will be under
My lord,
The-
election officer.
the
Sortebari.
election officer, Borpeta.
My lord, Sortebari, my lord. Sortebari under Barpeta district. My lord, my application is at page 30.
Page.
Page 30. My lord, receipt of acknowledgement of the application.
Uh, the election officer, Borpeta, who is the respondent number 2 herein, to
My lord.
provide the petitioner the certified copy of the voters list of 1971 pertaining to Kukarpa Gaon, Condo number 133, under 53 LAC, Korukhetri, to the petitioner within 15 days from the date a certified copy of this order is submitted to the respondent number 2. So this court further directs that the petitioner shall be liable to pay the usual fees for the purpose of the certified copy.
Deeply obliged.
Item 3,
Yes, Mr. Biswas.
This petition relates to the continuous remark against my voter list. And I made a reference also
You
there
are a devoter.
till today,
Since when?
in 2013.
And why the matter has come up today? Matter filed in the year 2024 and it has
And
come-
there is no FT case against me, my lord.
Advocate and the petitioner's signature not found. Notices not served on all respondent. Index incomplete. So you made everything okay on only now. So you don't have any urgency, isn't it?
My lord, your lordship can dispute, there is judgment of our own high court.
Which
I
one?
annexed it, page really.
No, I don't go by other orders. I have my order.
Page order.
Yes. We
Oh,
have,
I no order.
Lordship, if I may submit this case, your Lordship, the facts are there is lot of discrepancies. The age is completely, different. Like in 71, she was 21, she was 10, and she was
That is-
also 21 years of age. Thereafter, again, she changes her age to, like in 93, she was 33. Then she becomes 35 after 10 years. And also the name, Niva Rani Paul and Nava Durga Roy, there's a lot of discrepancy in this.
No,
entire
I am the
matter.
same person. I have made this way.
No, everything is okay. You have put them as D.
Yes.
He's not entitled to vote. But the fact that I can't decide that.
Yes, your Lordship,
Isn't-
yes, your Lordship.
So that has to be decided by them. Give me the AMU orders.
I have your Lordship, we can. just make
Yeah,
it.
give me the, which is the particular homosti?
It's Kamrup.
Kamrup, my lord.
Kamrup.
Kamrup where? D voter.
Rahiman Nessa. Rahiman Nessa.
If your father-in-law has not been declared illegal, how do you become legal?
Yes, your Lordship.
Then
Huh?
Father has not
I
been
have understood your
Father is
father
not-
have been made not declared
legal.
illegal. But the father-in-law,
Yes.
how does that have any relevance?
She has got that document that also she has given. to-
Which homosti we are not getting it? Where is that homosti? Where, in which voters list?
West Guwahati.
Huh? Yeah, not mentioned properly, Mr. Biswas. I'm very sorry to say. You should have been more careful. Whoever is drafting it, draft it in this manner. It's very difficult to find out because there might be tomorrow anything.
Page 31, my lord. Your
Where is
lordship.
your D voter? D475. What is your name?
My name is there, my lord.
Eva Paul.
Page 31, kindly see.
Page
Serial number
31,
4,
I'm
serial number 475.
8 to dispose of poultry. So you married your Your
My husband is
husband,
not devoter.
husband is not a devoter,
Devoter.
no problem. But how does it, obviously,
but
can't
I
a
bought
person
here-
from Bangladesh
Well-
come up here and marry Indian citizen?
My father came to India in 1951. A certificate issued by Deputy Commissioner, Refugee Certificate, Immigration Department. That also I have annexed. Then I was a student of Vishnupur Vidyaniketan.
You're going to silo it. এই to
Lordship,
voters
this
list.
is,
To silo, page 31 of the homosti voters list kon diya ase. He has been marked as the voter. And we have to ask SP border,
Yes.
Which one?
Kamrup Metro,
Kamrup Metro SP border,
DCP border,
huh?
DCP border.
DCP border,
Yes.
not SP border. Okay, DCP border. Is he a party?
No, my lord, he is not a part.
people who are parties. Yeah.
DCP border. So SP border Kamrup Metro is not there.
Yes, nomenclature is wrong, Lordship.
Okay, we direct
I
the
have made
DCP
my lord,
border.
wanted a police border, my lord, Kamrup.
We make it DCP border. It direction to DCP.
Diploma.
কি বলবো আর একটু Yes, what is this, Mr. T? Yeah, what is your name?
Non-payment of bill, your lordship. A dash.
On dairy.
Yes, lordship.
What is your name?
A dash, your lordship.
A. Das, Ankita Das. Non-payment of hiring bills.
Yes, your lordship.
Okay. Notice issued making it returnable on 10th of January 2025.
Lordship, this matter may be tagged along with WPC.
No
number-
tagging business. Okay, we have it on 19th of January 2025. You file your affidavit by 10th of January.
Hi.
Yes.
Lord,
Mr. B. Sinha, what is this?
Yes, my, here the NIT for settlement of fishery was issued on page 30, annexure 6.
So it has been issued in somebody's name. You are challenging what?
You're challenging, my lord, the impugned letter that is your lordship will find for retendering after completion of, my lord, the settlement process, retendering the annexure 10, the impugned letter, my lord. For retendering of the tender process of settlement of fishery was again issued. Page 40, annexure 10.
Then?
So, my lord,
Where's the
entire,
tender?
his entire process has been completed and I have been found as the highest bidder, my lord. Then matter has been transmitted to the government. Now, government has issued this impugned letter, my lord,
Which
not to
one?
this annexure 10, my lord, to retender the process.
Page
40. 40 is the page.
This is what date?
Date is 16/8/25.
Then? What is wrong?
So, my lord, here, my lord, all the entire process has been completed prior to, my lord, this whatever here, the Supreme Court order and the memorandum, office memorandum, whatever are there.
When was your
Yes, on 4/3,
settlement given?
4/3/25. Then, my lord,
Where is your settlement given?
no, my settlement not yet given,
Where?
but process has been completed.
How do you know?
Yes, because I have been found, the bid has been open, my lord. So I have been found highest bidder, my lord.
No, bad case.
My lord,
I have some orders passed, no?
my lord, here, that Supreme Court order I have annexed, my lord.
No, I know that.
Supreme Court order I have annexed.
Necessary. There are many.
Because the-
orders
the-
passed
the-
by-
Office memorandum was complied with, my lord.
It's bad case. Hey, he's on Nandan football. There was one person out there, what happened to him? Where he is not here? These people, they don't know anything. Oh. Fishery karne beleg ulare na. Many orders which have passed. Isn't it? Yes. He also doesn't know.
But Supreme Court order is after this, my lord.
It is-
But now, not only that Supreme Court's order, there is another direction. I have to find out. My earlier person, he was doing everything. He knew it. I passed similar orders. That case. No interference, because that 18.8 has not been enclosed, isn't it?
18.1 has been, I have enclosed here, I have
And-
enclosed.
and no, not only that, there is also the AR by the Fishery Department. Sad part is P. Sharma is not there. And are you aware? You are also not aware. This is also a sad part. I am handicapped by the fact that my person here, he is not there.
Let the
And
matter
I'm
come Monday then, my
also
lord, Monday.
handicapped- Oh, notice no. I'm also handicapped by the fact,
Notification is there, but 18-1.
what?
So this notification is.
81 is complied with.
18-1.
It is fully complied, my lord. 18.1 notification complied.
Complied when?
Madam,
Earlier.
while in
No,
the
was it made a part of the tender document? No.
no,
That is the main problem. Na. Why you are not understanding? That is why.
No.
And that has been followed by another order by the Fishery Department. But the sad part is that Fishery Council not aware of that. No.
81 I have enclosed, my in the annex are,
That I
annex are.
have seen it. But the Supreme Court direction is that you are enclosing a very short order of the Supreme Court.
There's a big order that,
Yes. You are not enclosing the order. of
that
the
order I
Supreme
do not
Court.
know. I do not know
No. That order you have not enclosed, where it has been mandated that you have to enclose. And without enclosing, you have to cancel. That part that these people have. I've got so many orders out here, it is not here.
The matter come Monday or Wednesday
No,
there.
we finish it today itself. Why should we have it? But I'm going to say here,
Yeah.
Miss S. Sutia is not aware of the law about the facts.
But the office name.
It's a very sad state of affairs, Miss Sutia. You are appearing for a particular fishery department. You don't know head or tail about those matters. Yeah.
But the department office order is.
Department? He also doesn't know anything.
No, madam.
You are just standing out here just for the sake of standing. It's a very sad state of affairs.
Enclosure 1 to 9.
25.
Huh?
10/7/2025.
He also is seeing from the mobile. He also doesn't know anything. Got it. Yeah. You see? The person concerned has properly kept it. But this person, he doesn't know anything. It's a long order I have passed. Yeah. It orders, right? Take it. Titelia, that was done in the case of Titelia Navajuti Matsyasewa SS Limited dated 21/5/2000 having have to be adhered to and any omission or lapse on complying with the said direction would render the NIT in question invalid. Then there is a direction on 10/7/2025, wherein it has been mentioned that now therefore and whereas based on the said judgment, the honor has categorically directed that henceforth all tender documents must incorporate a specific clause in the NIT stating that the documents and procedure laid down in the aforesaid year shall be mandatorily followed so long as the said circular remains in force. Now therefore in compliance with so and so, being the tender authority for settlement of so and so. Further mentioned that which provides for fixation of the annual leave, the order is issued with the approval of the computer and in compliance with the judgment dated so and so. The above quoted contents that the Supreme Court made it clear that all the undertakers have duly taken note of the NIT as well as the subsequent NIT data. However, it is in both the NITs are contrary to the directions passed by the Supreme Court in the case of so and so. Anyway, considering that both the NITs are contrary to the law, and the direction by liberty given to the fishery as well as to initiate a fresh setup process by following the mandate of so and so. And the earlier judgment of Justice, the Chief Justice and where it has been categorically mentioned that you have to have it. The Supreme Court only made it here. When so it is no doubt in the result the appeal succeeds and here we are informed that during the appeal the informed operating the fishery in terms with the settlement after the interim judgment was constituted. Heard Mr. B. Sinha, the learned counsel appearing on behalf of the petitioner. As these counsels, they don't know anything, I don't say that they have appeared. What do you want? Should I say that they have not appeared, or should I say that they have appeared but they don't know head or tail about the matter? Either. Not appeared. None has appeared on behalf of the state on call. The petitioner herein is aggrieved by the communication dated 16/8/2025 issued by the Joint Secretary to the Government of Assam Fishery Department, whereby the District Commissioner Borpeta District have been informed for cancellation of the said tender process for settlement of 64 number 64 Bargopa Wheel Fishery and go for fresh tender. By taking into account the Rule 48 of the Assam Fishery Rules 1953 and amendment notification on 31/3/2025, and further directing that the respondents, that the district commissioner should comply with the directions passed by the Supreme Court in the order dated 21/5/2025. while floating the fresh tender. The case of the petitioner herein, as it appeared from the materials on record, is that a notice inviting tender was issued
30, page 30,
on
4325.
4/3/2025. From interested bidders for lease of the fishery lease of the fishery, namely 64 number Borbhupa Bill Fishery under Khotebari Revenue Circle for a period of 7 years. Pursuant thereto, the petitioner participated in the said tender process.
Next on 9, page 37. Forwarded the matter to the government.
In pursuance to the said tender process, it was found that the bid submitted by the petitioner was the highest bid.
Yes.
And accordingly, the additional district commissioner fishery by the communication dated 25/2025 intimated the additional secretary to the government of Assam Fishery Department about the fact that the petitioner bid is the highest. Full stop. Pursuant thereto, on 16/8/2025, the impugned communication was issued by the Joint Secretary to the Government of Assam Fishery Department to the District Commissioner, thereby directing cancellation of the earlier tender process and going ahead for a fresh tender. It is under such circumstances that the petitioner has approached this court by filing the present petition. The law is well settled that the petitioner, that the law is well settled. It is, and again, this court have duly heard Mr. B. Sinha, the learned counsel appearing on behalf of the parties, who submitted that as the entire process was completed prior to
Yes.
the order passed by the Supreme Court on 21/5/2025, the question of issuance of a fresh tender does not arise.
Yes.
And the petitioner is required, therefore, the petitioner, and as such, the cancellation of the tender process was illegal, was with complete non-application of time. This court have duly perused the materials and record and have further taken note of the order passed by the Supreme Court in the case of Teteli Guri Navazuti
Matsyadevi Samata.
Samabhai Samiti Limited Cooperative Society versus State of Assam and others, wherein the Supreme Court categorically observed that the tendering authority will have to insert a clause in the future notice inviting tenders indicating that the government circular dated 18/1/2018 will have to be followed so long as the same is in force. Full stop. It is further seen that in pursuance thereto, this court further takes note of that similar matters have been taken up by this court on earlier occasions. That is, in the case of Sri Girikanta Das versus State of Assam and 3 others, WPC number 4355/2025, dated 4/8/2025, wherein pursuant to the order passed by the Supreme Court dated 21/5/2025, a circular, an office order had been issued by the Secretary to the Government of Assam Fisheries Department. The said office order dated 10/7/2025 have been incorporated in the order passed by this court in the case of Girikanta Das Supra. For the purpose of the instant case, this court further finds it appropriate to reproduce the said order. In the backdrop of the above, if it is seen above and perusal of the materials on record, it would be seen that the respondent authorities, that the respondent state, as per the Assam Fishery Rules 1953, is the authority to make the settlement. The state of Assam, the state of Assam had really intimated by the impugned communication dated 16/8/2025 for issuance of, for cancellation of the tender on the ground that the said settlement in the said initiation of proceedings for settlement of the 64 Bargopa bill fishery have not been made in terms with by taking into account Rule 48 of the Assam Fishery Rules 1953 and the amendment notification on 31/3/2025, which stipulates that the revenue of the bill fishery should be fixed for a period of 7 years at a time with 10% annual increment. This court further takes note of from the comparative chart that the settlements, the bid so submitted by the petitioner is not in consonance with Rule 48 of the Assam Fishery Rules 1953 as amended up to date. Considering the above, it is therefore the opinion of this court. Considering the above, it is therefore the opinion of this court. The question of interference with the impugned communication dated 16/8/2025 does not arise. Accordingly, the instant writ petition therefore stands dismissed. Before parting with the record, this court observes that the respondent authorities, while floating a fresh tender, shall duly adhere to the order passed by the Supreme Court dated 21/5/2025, as well as the office order dated 10/7/2025.
Item 6.
Mayor Fizology. So this petition be confined to the grievance of the petitioner number 1, because there is separate cause of action. The matter pertains to lordship cancellation of the fair price of license. Let's say on day before yesterday, the similar matter came up before your lordship. His lordship passed this order.
We'll have it on that date.
Yes, yes, Lord.
Yet 2, 3, 4 and
The
5.
date of order is also same, Lord.
2, 3, 4 and 5. Date of order is same, but all orders are different.
Yes, Lord.
Everybody has a separate order.
Yes, Lord. License.
Issue notice making. The same order we passed, Mr. M. Tretya. It will respond number, petition number 2, 3, 4 and 5 are struck off. Huh? Yeah. Are you have to do 2, 3, 4 lekha ase? Paragraph number 4 and paragraph number 5. All are 5 and 6. So 2, 3, 4 lekha ase 2, 3, 4 and 5. Huh? Baki kini same.
Obliged.
7.
Yes, Mr. Majumdar.
Lordship, this petition under
What
challenge,
has happened?
They're challenging an order of final assessment, Manoj, without availing the remedy under 127.
Lordship, we have preferred appeal that in, but here Lordship issue is that it was not done in conformity with the Electricity Regulation Code 2017, Lordship.
What?
Assam Electric Supply Regulation Code, Lordship, 2017. Lordship, sanctioned load is 24 and detected by Lordship theft is 0.08. But it was assessed against a whole sanctioned.
I'll appeal.
Lordship, appeal
127.
dismissed. Appeal dismissed.
They filed an objection to the provisional assessment. Thereafter, the provisional assessment was made final.
Then?
The remedy under 127.
What will you mean not done? Go there. File an appeal. Oh, it is, has to be filed within 1 month.
1 month. Manoj. The assessment is of June. That,
So
Manoj, may
we get
kindly-
it over. So
Yes.
we give him 30 days.
Yes.
The petitioner hearing heard Mr. L.R. Majumdar, the learned counsel appearing on behalf of the petitioner. Mr. B. Chaudhary, the learned counsel appears on behalf of the APDCL. The petitioner hearing is aggrieved by the impugned assessment bill. Provisional assessment bill.
Final.
19.2 is provisional assessment, na?
Yes, Manoj. Now, which has now been made final.
Subsequently made
Yes,
final.
yes.
Provisional assessment bill dated 19/2/2025. And the final assessment being carried out in terms with section 126 of the Indian Electricity Act. Mr. B. Chaudhary, the learned counsel appearing on behalf of the APDCL submits that the petitioner has an alternative remedy available in terms with section 127 of the Indian Electricity Act 2013. 3, na?
2003, Electricity Act 2000.
Electricity Act 2003. Mr. L.R. Majumdar, the learned counsel submits that the period for filing the appeal is only 1 month. Taking into account that the respondents have raised the plea of alternative remedy, it is the opinion of this court that the petitioner should, if the opinion of this court that if this court is required to relegate the petitioner to the statutory appeals, an opportunity has also to be given to the petitioners. Considering the above, this court without entering into the legality or validity of the provisional assessment order as well as the final assessment order, closes the instant writ petition, thereby granting liberty to the petitioner to approach the appellate authority in terms with section 127 of the Electricity Act 2003. It is made clear that if the petitioner approaches the appellate forum within a period of 30 days from today, the appellate authority shall decide the appeal subject to compliance with other formalities on merits. Subject to other formalities, other requirement, fulfillment of other requirements on merits. That is because you have to deposit something.
Item 8.
This case pertains to non-payment of contractual bill, Lordship. Higher.
Contractual bill and it has become so big. Go to the civil court. What is this matter about?
Matter, Lordship.
Non-payment.
Petitioner is the.
How many petitioners?
Or single petitioner, Lordship.
And how much is the non-payment?
The payment amount is 53,30,923.
And these are fresh, na?
Fresh.
Not old.
No, fresh.
Okay. It will issue notice returnable on 19 January 2025. Affidavit be filed on or before 10. Paikini likhi.
Item 9.
Yes.
Yes, your
Mr.
lord.
Mohammed.
Yes, my lord. My lord will kindly peruse page 22, my lord.
Page.
My lord, the petition, 22, my lord. My lord, the petitioner herein, my lord, before your lordship, is a my lord fair price shop owner under the Food and Civil Supplies Department, Government of Assam.
Why have you approached this court?
My lord, because of this show cause notice, my lord, at next page, my lord, 23.
It has come
My
to
lord,
the
will kindly-
notice of the understanding that
Yes.
16th of February you organized and participated in protest with the premises of the office without obtaining any prior permission. Your action disregarded the regulars and you are hereby called upon to show cause in writing within 3 days from the date of issuance of this notice as to why failure to then
Now, my lord will kindly come to page 20, sir. My lord, under this Assam Public Distribution of Public Order, my lord, these licenses are issued. Now, my lord will come to page 39. Clause 14. No holder of a license issued under this order or his agent or servant of any person acting on his behalf shall contravene any of the terms and conditions of the license. Now, my lord, 15.1. If any licensee or his agent or servant or any other person acting on his behalf contravenes any of the terms and conditions of the license, then without prejudice to any other action that may be taken under the Essential Commodities Act 1955, his
what
license.
does that mean?
Now, my lord will kindly see the reason why this show cause notice was issued. I participated in some protest, and because of that protest, I have been issued this show cause notice.
So go there, reply.
No, my lord, pursuant to this show cause notice, they have now issued at page 25 a suspension order. My license has been suspended at page 25.
It has come to the notice, page 25.
Yes, my lord. Oh, sorry, my lord, page 26.
No reply has been received within the stipulated time, and whereas so and so breed, whereas personnel of so and so. This was given on 29.
Yes.
Therefore, I so and so suspend the license. Okay. Submit your reply. Consider. You can suspend the license for long.
He has statutory remedy under clause 29 of.
No, not that clause 29, but you consider his case. Let him submit. He will submit a reply within 10 days. Consider and then pass the appropriate orders. Matter over. What is that?
My lord, but this show cause notice will remain, my lord, because of the.
Definitely it will remain.
Yes.
You are to reply.
Yes,
Oh,
but-
they have suspended. You are not coming to the main point. You have issued us on the question of so cause.
Yes.
So cause you have to reply. Why haven't you replied?
My lord, the reason why I have not replied, this is my second argument, my lord. The show cause which they have issued on 16, I have received on 28 because it was routed to the concerned Gaugura. I received on 28, and on 28 itself, they have passed this order.
Understood.
Yes.
So you should reply now.
My
I'll give you the opportunity. You
My lord.
reply. And within 15 days, this is because this is a fair price shop.
My
Don't
lord.
delay.
My-
Okay.
my lord.
Heard Mr. K. Mohammed, the learned counsel appearing on behalf of the petitioner. Because if I pass any order, I have to issue
My lord.
notice.
My lord,
And if I issue notice, the matter gets delayed.
my lord,
And at the end of the day, you will get the same order.
my lord,
Nothing else.
yes, my lord, yes.
So better I dispose it off so that you can get to whatever it is.
Yes.
And if you are aggrieved, you come before this court. I'm always here.
Yes. My only worry was, my lord, the nexus, because the show cause notice has to be
some nexus with the license terms and condition. That
You take up
I
those
understand.
all this.
Yes.
You notice, heard Mr. K. Mohammed, the learned counsel appearing on behalf of the petitioner, and Mr. B. Bukiel, the learned counsel appearing on behalf of the respondent numbers, all the respondents. Yes. On behalf of all the respondents. The petitioner herein is agreed by the initiation of initiation of a proceedings against the petitioner, as well as by the Ashoka's notice dated 16/9/2025, as well as the order dated 29/2025, by which the petitioner license have been suspended. The fair price license have been suspended. Mr. K. Mohammed, the learned counsel appearing on behalf of the petitioner, submitted that in terms with the Assam Public, what is that?
Assam Public Distribution of Articles Order 1982.
1982, for short, the order of 1982. Resort to actions can be taken by the authorities if there is a violation to the terms of the order or the license.
My lord.
The petitioner have not committed any such violation. Under such circumstances, it is therefore the case of the petitioner that the very initiation of proceedings by the show cause notice dated 16/9/2025, as well as the impugned order dated 29/2025, requires interference. This court inquired with Mr. K. Mohammed, the learned counsel appearing on behalf of the petitioner, as to whether the petitioner submitted any reply to the show cause notice. The learned counsel submitted that the show cause notice was routed through the Gambura,
My lord.
and it was served upon the petitioner on 29/2025.
My lord.
And under such, and in the meantime, the impugned order dated 29/2025 was also passed. Pusto. Mr. B. Bukiel, the learned counsel appearing on behalf of the respondent, though submitted there is a provision of appeal. But it is the opinion of this court that as the petitioner had not received the notice on the basis of which the impugned order, dated 29/2025 was passed. It is this court in exercise of powers under Article 2 to 6 of the Constitution can this court now, it would be in the interest of justice for this court to exercise powers under Article 2 to 6 of the Constitution. It is the further opinion of this court that the petitioner should be given an opportunity to reply. Considering the above, this court grants the petitioner a period of 7 days from today for submitting a reply to the show cause notice dated 16/9/2025.
My lord.
And thereupon, the respondent authority shall take such action if so necessary as per the ambit of the order of 1982, as well as the license issued by the petitioner. So, taking into account that the petitioner,
My lord,
petitioner would be at liberty to, this court further directs, the respondent authority, the concerned respondent authority to take a decision as regards the so-called proceedings upon submission of the reply. at earlier, at the reply. At, expeditiously taking into account that the shop of the license of the fair price shop has been suspended, which eventually affects the public.
My lord,
The
please-
said expeditiously and not later than 30 days.
My lord, this order of suspension will remain or my lord will go?
I can't touch it because if I touch it, then the question is as to whether you have received it on 23, 29
Yes.
is a question. See, anyways, you have approached this court in the month of October.
My lord.
So you submit, I've given them within 30 days. If I set aside today and say, I could have very well set aside,
My
but
lord.
this only when they say that you have received it on 20.
My lord, I have annexed one document showing that I have received on the 23.
That you have approached late before. If you have approached immediately, you have been different. You get it done, you file and you reply within 7 days. I pass that order, they will duly consider.
My lord. Please, if I may be allowed to continue.
How can I allow this one? Because without hearing them, if I allow them to continue, it would be wrong. Don't you think so?
Item number 41. Similar matter as that of item 9, my lord.
Same.
Same, my lord. Same issuance order. Because the incident which was mentioned in the show cause, it was stated that all these 5% were also there, pursuant to other 10-15%.
All were received on 10/9.
All were received on the same date, all were issued on the same order of suspension, also same. Only the memo number will be different.
Same order. Okay. Mr. MCT. Same order. Mr. Bukial was there, na?
Yes.
You can. Should I put his name only? Apo order to me. Huh?
13.
My lord.
May I please, Your Lordship? Lordship, the petitioner herein had purchased the tea factory in the year 2009, my lord. Thereafter, when the petitioner had exceeded the minimum threshold for getting itself registered under the ATP fee of a Act, my lord, by application dated 25/11/2024 at page 55, the petitioner had applied for registering itself with the authorities, my lord. Till date, no reply has been received by the petitioner.
So you have asked for registration.
Registration.
They have not allowed.
No, Lordship.
Why?
No reply has been received, Your Lordship.
Oh,
Yes, Lordship, what is happening, there is a change of law. Now the factories would also be deemed to be like plantation. So they have sold the factory to another third party. That sale has taken place in the year 2009 itself. And the law has changed in 2013. So they were bound to inform us. Be that as it may at that time, but they had informed in 2024. Now, we don't know that application is the simplicity application, the factory to be registered. Now we don't know whether the workers that were engaged in the estate as such, some has been transferred or entirely they will absorb, because then the board will have to be changed. There will be different board membership.
you are saying all these things. Why you are not informing him?
Yes, we have done an inquiry also on the basis of that.
So why you are not?
We had
informing?
purchased, Your Lordship. We had purchased the factory, Your Lordship.
They had purchased.
We had purchased the factory from a third party. And thereafter, in 2013, my lord, by circular,
So I'll bring that report on, I'll bring that report because we have also done a report on the basis of the application. The-
Why you are not giving him the report? He can know then what to do.
Yes, we'll supply that. Then,
And he can comply with it,
yes, then,
isn't it?
Lordship,
So what should I do?
Lordship may issue notice.
Issue notice, I'll produce the report or
Now, if I issue notice only, his problem is not solved. at the end of the day, you are going to give him only the report again, he has to do the same thing.
Whatever
Let
necessary.
us do one thing. Let us have this on 4th of November. Today is what? Oh, no. Let us have it on 29th.
29.
29th.
Not sure.
On that day, you get the report. On the basis of that, we close it and say that he will duly comply.
Not sure.
If, on Friday then?
Next Friday, 31st.
Yes.
Okay.
Not sure.
31st, you bring that report on the basis of what inquiry it is. And we'll close it on that day, giving him that the reasons. He is only aggrieved by the non-providing him the consideration. You are considering it and you have therefore have any report on the basis of that. You place it and on the basis he will do the need. Mr. R. Sharma appearing on behalf of the respondent submits that pursuant to the application submitted by the petitioner in the year 2024.
Well, 25/11/2024.
24. An inquiry has been duly conducted and he would like to place the report to list this matter on 31st of October 2025
Obliged.
Deeply.
for motion.
Supplementary item 33.
May I please? In this case, my lord, on last occasion, your lordship directed me to file additional affidavit being on record.
You have
And
not
yes-
filed the additional affidavit.
Yes, my lord, I have already filed it. Yesterday, I have filed, my lord.
They have not come on record. Neither you have called for that. Mr. Alam, the learned counsel submits that he has filed an additional affidavit on 23/10/2025. This matter on 27th of October for motion along with the said affidavit.
My lord. Obliged, my lord.
34.
Kindly pass over for a timing, Lordship, on his way.
What is this?
Lordship, we have been technically found non-responsive, Your Lordship. By minutes of meeting dated 9/10/2024-25, Your Lordship.
NIT,
NIT, Your Lordship, is that
what do you
page?
mean by way of an additional affidavit?
Lordship, that is our documents, that is annexure 1 of appendix 1A, Your Lordship. NIT is at page 46, Your Lordship.
Okay, what is your case?
Financial grade has opened, my lord, and L1 has been declared.
It's okay. We can, if we have a good case, then we can very well pass an order not to issue the tender work order, isn't it?
Lordship will come to page.
Which are you?
No.
The technical evaluation committee, after several rounds of sitting, they have declared out of 29, 14, including me. So that was forwarded to the screening committee. Now, screening committee, my lord, on 8/10/2025, they have also accepted the technical evaluation committee recommendation and found me to be, my lord, responsible.
So you have been held to be non-responsive.
By the subsequent, my lord, on 8th, I was declared responsive. On 9th, the screening committee again said and taken note of my lord, internal communication of the department and said I am my lord, non-responsive
Why?
because of certain my lord, workload.
Show me that report.
Lordship.
What is your name? Tenor Engineering.
My lord, 302, my lord,
Wait,
page 302. My lord, on 8th, I was declared responsive. That minutes just my lord, before this, my lord. Lordship, may I kindly first, my lord, come to page 299. This is the screening committee recommendation. Up, paragraph 7, upon scrutiny of the technical evaluation board proceeding, it has been observed
Technically responsive.
responsive. Then it was on 8th, then 9th, they have said that is, my lord, page 30.
Now, why you have been held to be not technically
Yes, my
responsive?
lord, paragraph 3. At the outset, the chairman welcomed all the members of the committee and briefed them on the purpose of evaluation committee and the responsibility of each member in accordance with the prescribed guidelines and procedure for the bid evaluation. As per the last second meeting held on 8 October 25, the screening committee had recommended 7 bidders out of 29 as technically non-responsive. Based on the recommendation of the screening committee, Messrs. Tenor Engineering, Satish Agarwal and Company, JB, P Sector, Itanagar, so and so, has recommended as technically responsive bidder. However, it has now been observed that as per the workload return WLR of the quarter ending March 2025, circulated by HQ so and so letter number so and so dated 31st July 2025 at serial number 45, Tenor Engineering Arunachal Pradesh has been marked as no under the remarks column 4 being considered capable of handling additional load. There is no such clause in the NIT method. Now, Lordship, may come to page 309. Now, it has been observed that as per the workload return for the serial number 6, my lord. Now, it has been observed that as per workload return WLR of the quarter ending March 2025, circulated so and so March 31st July 2025. Tenor Engineering also has been marked as no under the remarks column for being considered capable of handling additional load. And then, my lord, paragraph 10, page 310. Hence, in accordance with WLR QE March 25, the screening committee has considered Messrs.
Can you
Tenor,
come to paragraph 7?
my lord,
Paragraph 7.
para 7.
Page 310.
It is further highlighted that during examination of various shortfall documents were served by the screening committee in respect of Messrs. Tenor Satisfactory Company, specifically concerned Messrs. Tenor Engineering, as also referred at paragraph 5 above on such observation as under. As per annexure 1 of appendix 1 is submitted by the bidder, it has been declared that bidder has been barred by the Ministry of Road Transport Highway on its implementing agency for participating in bidder for works related to express national highway, interstate connectivity and economic importance project. The bidder may be asked to provide detailed clarification along with relevant documents, evidence regarding the nature, duration and current status of the said development if applicable. In response to the above, Messrs. Tenor Engineering provided their letter number so and so dated 30th September submitted under the shortfall has stated that no development subsists as on the bid due date. They have also provided detail of the past development issue by the respective department as under. Well, this does not contain about this letter dated 31st July 2019. This so-called reply is at page 230 and the notice is at page 288. And in fact, the last bid due date was 18/6/2025. This clarification they have accepted, and on 8/10, they have the technical evaluation committee has found me to be responsive. That
Now show me workload return. You have been held to be technically not responsive on the ground that you have not provided any clarification or comments regarding no remark against their name for capable of handling more load. As mentioned in the workload for so-and-so issued by the so-and-so. What is this aspect?
Well, this we have not seen that, my lord. This has never been issued to us. This is not a part of the tender also. It was issued on 31st July 2025, whereas my lord last bid due date was my lord 18/6/25. There's no so-cause on this also that will be my lord unable to handle the workload, etc.
So you mean to say that these additional terms was incorporated subsequent?
It was not even a part of the, my lord, RPF, RFP, my lord. Nor the, my lord, this copy of the 31st July was issued to me, asking me to show cause, my lord, that you are not so, so why you should not be debarred, or why you should not, your tender should not be rejected.
Yes, Mr. Gupta, what is the?
Matter was filed yesterday only, but I will take clarification. I have asked note, can it be taken up at two? The letter dated 31/7, which will under 20th April. That also I will produce, my lord. At two.
Produce it and just find out.
My lord.
His basic contention is that this is not a term in the contract.
Yes, that.
And secondly, he says that if it is not a term in the contract and you want to insert this
My lord.
as regards having capable of handling additional load,
My lord.
is now being sought to be incorporated out there. It means you are changing the goalpost after the finalization, after the submission of,
Yes.
which you cannot do so. That is his submission.
No.
You'll have it at two, you will
Exactly,
just get.
same query I have asked.
And this order happened when?
My lord, 9/10, my lord.
Uploaded on 30.
9/10,
Uploaded on 13/10, my lord.
9/10. Now you have submitted a reply.
Lordship, my lord. This page 230, my lord.
313.
And so cause they had issued, that is at page 228.
That was regarding blacklist.
You obtained the instruction in respect to paragraph number 1 and 2 of his representation.
Yes, it last.
Thank you.
For admission item 15.
Oh, yes. What is this? Yes, I asked you this. Does this have anything to do with the central government? No.
It's under.
So it's the state government along with the BTC. This is for non-payment of dues.
Yes, my lord. My lord, this amount is already admitted in the earlier round of litigation, my lord.
Huh?
Yes, my lord. This is the second round of litigation.
Show me.
My lord, annexer 15, page 49. Page 49. Operative part is, my lord, page 50, my lord. Third para, my lord.
वैसे तो पाई है
नहीं,
14 को पाई
नहीं, दिया ही नहीं.
So he has been asked to pay as per Tamsarali.
My lord,
Then what happened?
not paid till date, man.
Huh?
Not paid till date, man. This
So
is
the
this order.
direction has been given to the chief engineer. Do you follow Tamsarali? Does Water Resource Department follow Tamsarali? Do you have a chronological list? This being the second round of litigation, there's already the executive engineer has already given a thing that he is entitled to rupees 9,21,000 and all. Now, therefore, the court has directed to again re-verify and then And more particularly, direction is given to the chief engineer to re-verify. And if so, pay the amount in terms with Tamsir Ali. But my question is, does Tamsir Ali appear to apply to you, the Water Resource Department? Because Tamsir Ali is actually a case between the litigants as well as the PWD, where the PWD consented before the full bench. So you have to give us a good the reply as to whether you have considered in the case of the petitioner in terms with Tamsir Ali. And who is to make the payment?
The PTC, because this is a transfer subject, Lordship.
Maybe.
Yeah.
When it was created by the Home Department, the Pension Department, and minor the finance. Is the state sub. And BTC, whatever the work's been done, approved, and therefore it's been completed. Now this is to send to the state government and they approve the financial. This is the minor scheme under which BTC runs. They have no fund of their own. Finance is nothing as well.
No, finance is not a transfer subject, it is understood, but the water resource is.
Water resources, minor, whatever tanks for government of Assam. And whatever funds are allotted to by government of Assam, minor, by which this work is done. And every year, minor, when the bills are raised and everything, the process, ultimately, it's the state government who.
No, are we to understand that you have issued a work order to the petitioner
Yeah.
without having the funds?
That minor in 2014. At least.
And
my
officer under your department
Yes, that's true, minor.
have categorically mentioned
Yes,
that he is entitled to that amount.
yes.
What actions have been taken thereafter?
That instruction, minor, I have to.
Done well, because this is the second round of
Yes,
litigation.
I know.
Doesn't look nice. That
Yes.
once the court has, first of all, in my opinion, Tamsir Ali does not apply. This is the case, I would have otherwise passed a direction for payment of this, making verification and payment within 6 months. But this is not a case which I can do so, taking into account that this is the second round of litigation. And he alleges that you have neither followed Tamsir Ali. Isn't your allegation or not?
Well, yes, my lord. And my lord, already it is reflected in the order also.
Reflecting the order.
So it is his case that Tamsir Ali has not been followed. Anyways, Tamsir Ali means you have to maintain a chronological list.
Yes.
And in the chronological list, you will pay as per the funds whenever you get it.
Yes.
So therefore, is your department out there, the payment has to be made by whom? The executive of the engineer.
Yes.
Concerned division will make the payment. This concerned division will make the payment provided the funds are made available.
Absolutely.
So whether the funds have been made available to them for making the payment, or are they maintaining a chronological list? That is the question. If you are not maintaining the chronological list, the direction as regards payment for as per Tamsir Ali would be wrong. So we need to correct it. Don't be at the mistake of the court, the petitioner will suffer. So therefore, you both of you just find out and let me know as to what is how do you make the payment, because this is the second round of litigation.
Well, the BTC minor, including the PW department, they follow the Tamsir Ali case. Because liability is huge, minor. And for that purpose, all contractors, there has been a list been
So
made.
therefore, if you follow the Tamsir Ali, the petitioner must be put in
Absolutely,
somewhere in the
that's exactly
chronological list.
Absolutely right.
So therefore, give us the details as to where have you put him in the list.
Yes.
Then he can very well be satisfied. that coming to the court makes sense. Isn't it?
My lord.
This is the second round of litigation. In the earlier round of litigation, this court passed a specific direction. In the earlier round of litigation, being WPC number 5025/2014, This court passed the direction on 13/6/2017. Thereby directing the respondent authorities, directing the chief engineer. Now you see the direction is upon the chief engineer.
Yes.
The chief engineer of the Water Resource Department to re-examine the statement of the outstanding liability made by the executive engineer, Kokrajhar Water Resource Division. Dated 28/10/2014. And as per direction passed in Tamsir Ali and others versus so-and-so reported in so-and-so, the chief engineer was directed to take a decision on the matter within a period of 3 months from the date of the order. And if it is found that the petitioner's claim is found to be genuine, the admitted amount be paid to the petitioner. It is the case of the petitioner that in spite of such directions passed by this court on 13/6/2017 in WPC number 5025/2014, the petitioner have not been paid his dues, which necessitated the petitioner to approach this court again. The record reveals that respondent number 4 has filed an affidavit in opposition. Whereby the respondents have taken a plea as regards the question of jurisdiction, but they of have taken a plea as regards under whose authority the papers, related papers are. But the stand taken by the respondents, but there is no stand taken by the respondents as regards what steps have been taken in pursuance to the order passed by this court, dated so and so in WPC number 5025/2014. Insofar as to whether the petitioner herein is entitled to the said amount after the verification being carried out by the Chief Engineer, Water Resource Department. And further, as to whether the petitioner have been put in some chronological list, which is the mandate as per Tamsir Ali Supra, so that the petitioner gets his dues when his turn, as per his turn. List this matter on 10th of November 2025, on which date the Standing Counsel of the BTC, Mr. A.K. Bhuiyan, the learned counsel, as well as Ms. So-and-so, who represents the Water Resource Department of the Government of Assam, shall apprise this court. List accordingly.
16.
Mr. Naik, where is he? Any instructions? Where is Mr. Naik? Who is appearing for the PWD? None has appeared for the PWD. Let's see the face of the Chief Engineer PWD. Where is he? Okay, none has appeared on behalf of the PWD on call. Pusta. Resultantly, the instructions which were sought for by this court on 15/9/2025 have not been placed before this court. Accordingly, this court fixes this matter on 7th of November 2025, on which date the Chief Engineer PWD Building and National Highway shall be present through the video conferencing link on 14th November. Shall be present through the video conferencing link at 10:30 a.m. It is further observed that in the circumstance that the Chief Engineer PWD is not present to the video conferencing link, this court may be constrained to issue appropriate directions for his personal presence in the court.
17.
Seeking apology, Lordship. In this case, I have to file affidavit. Lordship, somehow, Lordship, our file was misplaced. Today, we have recovered. Lordship. So, Lordship may give some time, Lordship. Even our communication also not done. Lordship.
Fair price shop has been cancelled.
Lordship.
Yes.
Even otherwise, alternative remedies also there, Lordship.
That is also
Yeah.
pending for a long time, my
It
lord.
is
They have
there.
not considered it.
It is there.
That,
You have filed an appeal.
yes, appeal is also there, my lord. They have not decided it.
And Lordship may dispose of
They have not decided the appeal, my lord. This is second round of writ petition, my lord. Earlier occasion, my lord, without issuing shock cause notice, matter were pending with the deputy commissioner for a long time. Then I approached the honorable court. Lordship, please to pass an order to apprise the court about the action taken. Then, my lord, Lordship kindly see Lordship's order, page 62.
Now, you have filed an appeal. Why should be there parallel?
Lordship.
Anyway,
We direct the respondents to dispose of the appeal within a period.
well, since there is an order file affidavit, my lord, they can come up with an affidavit about the status of my lord, my appeal. Since they have not decided,
Why do you need? We direct them to decide the appeal. Matters, you see, if you have not approached and filed an appeal, it's a different
Lordship.
aspect of the matter.
Lordship,
You have filed an appeal.
yes.
So that we direct them to the unnecessary. Why do you trouble Mr. K. Gogoi? He's otherwise a very busy counsel.
But in the, my lord, imping
Never
order.
heard Mr. J. M. Chaudhary, the learned counsel appearing on
Like
behalf
this,
of
one
the
of the time.
petitioner.
Account.
Mr. K. Gogoi appears on behalf of the respondent numbers 1 to 4.
Lordship.
Full stop. Though a final opportunity was granted to the respondents to bring on record the stand by filing the affidavit. But it has been brought to the attention of this court that against the cancellation of the fair price shop license of the petitioner,
Yes.
an appeal in terms with clause 29, na?
29.
Clause 29 of the Assam
Public distribution orders
Order
1980.
1982 have been filed and which have been pending before the appellate authority. Mr. J. M. Chaudhary, the learned counsel, appearing on behalf of the petitioner, that there has been there is a delay in disposal of the said appeal which necessitated the petitioner to approach this court.
Lordship.
It is the opinion of this court. This court inquired with Mr. K. Gogoi, the learned counsel, appearing on behalf of the respondent as to within what time the said appeal can be disposed of. The learned counsel submits as the writ petition is also pending, the respondent or the appellate authority have not disposed of the said appeal. He therefore submitted that the appeal can be disposed expeditiously. Considering the above, this court directs the appellate authority, that is the director,
Commissioner Secretary, Lordship.
Commissioner and Secretary.
Commissioner and Secretary to the Government of Assam Food and Civil Supplies and Consumer Affairs Department to dispose of the appeal filed by the petitioner when
That date is not available after.
filed against the cancellation order dated
Dated, my lord, 22/1/2024,
and so
page 68. 68.
against the cancellation order dated 22/1/2025 within a period of 45 days from the date a certified copy is served upon the respondent number 1. Upon the Commissioner and Secretary to the Government of Assam Food and Civil Supplies and Consumer Affairs Department. It is observed that in the circumstance the petitioner is aggrieved by the result of the said appeal, it shall not be a bar on the part of the petitioner to approach this court. Personal appeals. We want to see the same.
Both affidavits will be filed today. One has been already given to the clerk.
What? None has appeared.
I was in Lakes in court number 9 in this floor.
Why you are taking the blame? Mr. P. Nayak was supposed to appear.
No, my lord, only for PWD. PWD has been given personal appeal. Because the NSM is also there, my lord.
Oh, NHM, no. Well, because it is stated that out of that particular amount, some 2 crores have already been paid.
Yes.
Remaining some amount is there of 52 lakh, which wherein the payment would be made on account, the payment could not be made on account of shortage of funds. And remaining as regards the 12th RA bill, the said amount would be paid immediately. And this court only sought for an update. The chief engineer did not give an update. So let's see the face of him on 14th. It's an auspicious day. 14th November is an auspicious day. Isn't it a Children's Day? Yeah.
You will kindly see the affidavit that we are going to file today, my lord.
No, why do you need an affidavit? We only asked for that.
No, updated instruction, they have filed an affidavit.
PWD is not appearing, so.
My lord, today I was entrusted, I was in court number
Okay,
9.
get hold of that lawyer who was there.
Yes,
I
I
will
will
pass
try.
the order only in his presence
I will-
again.
I will.
Otherwise, no.
Item 18.
Yes, what is this?
Lordship, matter may be passed over for time being.
Why?
Youngest counsel is Lakes India,
Who is your senior counsel?
MS Thakuria.
When did she become a senior counsel? Who make all this make it?
May I pray, my lord? Here, my lord, I have gone through the last order, I have taken out the printout order. But I am in a position, my lord.
Oh, that matter.
Yes. Now, whole of the records, my lord, yesterday evening I took up the matter when I saw in the cause list, my lord. And I made all the efforts to bring all the records here. And a supplementary record is also being there, para-wise comment is also available there. But only the problem in the para-wise comments that the case number has been wrong here.
You see what has happened?
Yes.
The petitioner herein have submitted the bid in the auction process.
Yes.
But the BTC authorities, as they are, they have given it to the respondent number 6 and 8.
Yes.
Now, the petitioner is not in a position to serve in view of the fact that she doesn't know the address of the respondent number 6 and 8.
Fine.
And the BTC authority who have sold it and handed over the possession is also not coming forward to give the details. And that is why I asked why we should not impose a cost of 1 lakh.
Fine. I will folded hands pray, my lord. I have taken out the responsibility with regard to this, my lord. Even the records yesterday 9:30, it's been delivered. Fine. All to be assembled, all years wise basis. My lord, what I am on record is there. I'll call up the person after perusal the record. I'll find a detailed affidavit with regard to this and what is being wrong and what is right. Because record is
You file your
available to me.
Because we want the address
Yes.
of respondent number 6 and 8.
I'll assist.
You don't sell. It is not like when a government authority sells any particular thing on auction.
Yeah.
Certain address, everything is taken.
Absolutely, I'll check it.
It cannot be that you just come up on the shop and go to a pawn shop and get all these things. No, it's nothing like that.
Yes.
So you have to get this.
Yes.
Okay, Mr. A.K. Bhuyan, the learned counsel submits that he has been recently engaged as a counsel for the BTC. And yesterday only, he had been provided with the brief. So that, and as such, he requests some time to look into the matter. Taking into account the above, list the matter on 17th of November. On which date? The BTC authorities, the respondents in the BTC shall take appropriate steps in terms with the order dated 22/9/2025.
Oh, wow. After the department. Oh.
Yes, for the-
19.
G Bora.
That's it. So I have received the instruction detail, that's it. Admitted amount, that's it. Some time may be required, that's it. But so I'll file affidavit because para is coming receive, they only know.
Given by that legal officer.
No, that's it. This is an item.
Ah. You got the instructions, huh?
That's it. In, para 4, that's it. They have admitted it's a liability. Amount is, I have verified, amount is correct.
25 lakh, 26 lakh.
26.
How much is the total? 23 and 26.
But 23 lakhs, 89,500 we have already received, my lord. 23 lakhs,
9,000
89,000
you have received.
received, my
So
lord.
remaining is 26.55.
Yes, my lord.
Process is going on, that's it. Some time may be required.
No, we do one thing.
That's it.
We quote this paragraph 4
That's it.
of this instruction and give you time for 6 months. You are asking time till 31st December.
Right.
I'm giving time till 6 months from the date a certified copy is served upon the director. You dispose of query. Huh? Instructions kept on record and marked with the letter Y. 24/10/2025. Our paragraph 4 to quote query. Huh?
Obliged.
6 months.
Item 20.
Payment within 6 months. Verification na lang. Yes, what is this? Ratul Chandra Roy. Who is he? Monojit Shettia.
May I please, Your Lordship?
Ah.
Lordship, the petitioner, he was the selected lessee in respect of a eco park, my lord. The eco park has been developed by Assam Tourism Development Corporation Limited, my lord. And they have already filed their affidavit, my lord. There are altogether 14 components in the contract, my lord. Out of that, 12 components have been handed over to the lessee, my lord. 2 components have been handed over, my lord. The 2 components which were not handed over, that one is the parking and the second was the ticket counter, my lord. And the opposite party, they have already, ATDCL and government has also filed their.
So you were only handed over with 12,
12,
not 14.
Not 14, my lord.
So therefore, your case is that you have submitted representation which have not been considered.
That has not been considered, and the government is, the ATDCL is claiming that that has been developed by them, these 2 components, and the government has filed an affidavit in which they have claimed that those 2 components were developed by the their local fund, by the development, this thing, Tarapati Development Officer, my lord, BDO has developed that out of his own fund, my lord. That is the claim of the government, my lord. And ATDCL, they have already filed their.
But Mr. Rajsekhar, tell me one thing. If you have entered into a contract
Yes, my lord.
for a particular Koya Kujia Eco Park
Yes, my lord.
property, and out of the 14, only 12 have not been given. Have been given.
Yes,
Only 2 have not been given.
yes,
Thereby, a loss has accrued upon you,
yes, my lord.
and for which you want them to hand over that.
Yes, the remaining 2.
Now, their categorical stand is that it is not a part of that property. They could not have been given by
ATDCL.
the response number 2.
Yes, my lord.
Now, resultantly, a loss has accrued to you.
Yes, my lord.
So why don't you file a civil suit on this basis? Because it's a case of money.
Yes.
And when there are disputes as to whether he should give or not, and by the time it finishes, this matter finishes, you have, at the end, it is only the question of compensation. Don't you think so? It's okay, there is no problem with that. But by the time the matter finishes, you got it in the year 2023.
Yes, my lord.
We are already in 2025. And it was given for a period of 5 years.
Yes, my lord. The agreement was signed in 2023, my lord, in May. But as per the clauses of the agreement will start running on the date on which all the components were handed over to the petitioner, my lord. So, and because of that, 2 components has not been handed over to the petitioner.
So you say that the agreement is not running.
Not yet running. It will start running on the
But
date on
whether
which.
the 14 components were there.
Yes, my lord, in the agreement itself.
Petition by tender.
Yes, my lord.
And could this respond number 2 hand over if the property does not belong to the respond number 2?
No, your lordship will kindly look at the affidavit filed by the respondent number 2 to 5, my lord.
Who is appearing for the others?
When I'm reviewing, but that particular property part was handed over or the agreement was executed within 5 years the petition, brought by the respondent to. The APDCL who has been tendered and accordingly allotted to the lead petitioner. Stating that this 14 components which are mentioned in the schedule A will be released out to him for factor. Now, my lord, respondent, in the meantime, respondent it has said it and stated that, my lord, out of the 14, 2 properties, there is the photo gallery and my lord, the boundary wall along with the gate and the parking. It is they who have constructed. Respondent A. So, my lord, the petitioner cannot have any, my lord, authority on this particular component of the.
So therefore their stand is that the the respondent for whom Ms. Golua is appearing did not have the authority to include it in the tender.
So, tussle is between my lord 5 and 8. And the petitioner is suffering other.
So therefore, how can it belongs to them or them? How can this court decide? I'm
And
angry
there is
on
the
that.
arbitration clause also, my lord, clause number 20 in the agreement. Otherwise.
Isn't it the case of disputes which requires for you may be entitled for compensation?
If you'll also kindly have a look at the affidavit filed by the ATDCL.
Now, AGC, they have done a mistake. Let us assume.
No, that has
they
been
have done a
constructed.
mistake. And even these 2 properties also. There's no denial of the fact that 14 components were a part of the tender.
Yes, my lord.
There's no denial of that. But the fact remains that the respondent number A claimed that they could not have given the 2 out of that.
No, government of Assam has taken a policy decision to hand over to run certain tourism spots on private participation basis, my lord. Accordingly, they have taken a decision. Cabinet decision has been taken, my lord, and they have already annexed the notification issued by the government of Assam also. That is in page 284, my lord.
280. Actually, your lordship, if I may submit in this regard.
Please do submit.
Lordship, the affidavit filed by Assam Tourism from respondent number 2 to 5. In that affidavit, your lordship, at page 284.
284, yes.
So it's page 280 to 83. It is actually, your lordship, the Ministry of Tourism had actually sanctioned 3.79 crores for the development of this
Whatever
Koya
park.
Kujia Park. If your lordship has page 280 to 283.
This is given by the government of India.
Yes, your lordship. The government of India, actually before 2009, what the SDO, what the Koya Kujia committee was doing, they had developed the fisheries out there. So there was a scheme under the Manrega scheme.
Okay. Now the question is, has everybody filed their
Yes, your
pleadings?
This respondent 5 years filed that.
8 has filed.
Eight.
Respondent 8 has filed. So
Are all the pleadings complete or not?
Yes, my lord.
yes, from our side it is complete.
Complete. Okay. Taking into account the pleadings are complete, this matter on 9th of December 2025 at 2 p.m. on which date an attempt shall be made to dispose of the.
Possible, sir.
Of the district. Ninth.
Yeah. Done, isn't it? Where is your counterpart? Without your counterpart, it can't be done. There.
60.
And let it be next week along with the affidavit. Both
Have you filed the affidavit?
of PWD, we are filing it today. NSM, just now I got the signed copy. It will be filed today.
Mr. B. Gogoi appearing on behalf of the PWD as well as for the NHA submits. Few affidavits have been filed on their behalf. To list this matter, affidavits on their behalf by providing advance copy to the counsel for the petitioner. List the matter on 17th of November 2025. In the meantime, liberty given to the petitioner to submit any reply, if any.
Wait, please, Lord. I'm appealing for Mr. R. Islam, my lord. In this case, right now, my lord, after half an hour back, my lord, the affidavit in opposition filed by the respondent number first.
What?
Half an hour ago, my lord.
Affidavit in opposition file.
File.
Okay, Mr.
Appealing for R. Islam, my lord, on behalf.
The counsel appearing on behalf of the petitioner submits that the affidavit in opposition, I won't mention your name. Mr. J. Hendig appearing on behalf of the Revenue Department submits that the affidavit in opposition have been duly filed. The counsel appearing on behalf of the petitioner seeks an accommodation to go through the same and if necessary to file a reply. List the matter on 21st of November 2025. In the meantime, liberty given to the petitioner to file reply on or before 19th of November 2025.
22.
Hey, your justification does not seem to be proper. You are getting 2 crores 70 lakhs. 2 crores? No, 1 crore 43 lakhs.
Yes,
It is 1 crore. The highest was 282.
yes.
You are getting 143. Now you're, by the time it is going to end, you are not likely to get even that. You have only got 71. The reason doesn't seem to be proper.
Lordship, we have been in the position of the gate since January 25, Lordship.
You were supposed to give these from the month of May. And from May till December, isn't it? They quoted 143. It is not that they should get it. It should have been given under 282. The first highest was 282. Maybe he may not. He's number 4, if I'm not wrong. He's number 4. So he had quoted some 143. It's okay. But the fact that your basic reason is that in another gate you are getting 5. So you have said that you get more, but there is already a writ petition pending in another 5 where the first bidder did not pay the 5 and you are giving it to the number 2, isn't it?
No. They are not giving it to the number 2. Number 2 has come before the court saying that number 1 has not deposited, terms of settlement has not been fulfilled. That statement is there in paragraph page 53 of this writ petition also. Earlier one writ petition was filed, court said you file a representation, then come back. That petition is pending. The person with whom it is settled, he has not paid the amount, but yet settlement has been made. And here
So, this very bad. I've never, across last 4 years, I've never heard of a case like this. It's unique to NC Hillsong. Isn't it? I understand your predicament in defending such action. It's a very difficult thing to defend. That is why from here now it makes it very clear also that you are losing when you are collecting by yourself. Instead of that, if you have given it to him, you would have got. Now, if you give it for the next 2 months, so we do one thing, only the November, December. Next week, we take it up at 2 and finish off this matter along with the other one?
Yes.
The other one is, why should we require the other one?
The other one, my lord.
Don't bring
It's all right, my
another.
lord. See, if you are
Why
also
do you give
taking
me
into
the headache
consideration
of another matter?
For the purpose of.
The installment, pre-installment, we have received the first installment and second.
Let us not go into the other.
That's all right.
But the fact from here, it appears that your decision to do it was not proper. It doesn't appear to be proper. So we interfere with this and direct you to go ahead and settle the tender as per law.
As per,
The decision they will have to take within a stipulated time.
Can we do it today?
so
At
that,
2?
that will be done.
I don't have much matters. Minister. Short order. Besides,
Yes, yeah, and it is covered by your lordship decision.
only the fare is so many councils are there. Are there many matters today? How many matters are there in the list today? I don't see the list. 51. Okay, itu QN number do you see? Not much matters. Okay. We can finish it off. As the last item of the day, we take it up today. It's matter, and we'll finish it off. We pass the order.
Yes, my lord, last item. Yes.
Huh?
It's all right. If I'm not there, my friend will be there.
Oh, none appears for the petitioner,
No,
will
no, he'll
make
be
an
there.
argument. Oh, if he is not satisfactory, don't think that I'm going to allow.
Next week.
No, we finish it off today. Because you
I'll be-
are losing.
Yeah, lordship.
You may, because why I'm saying is, you will first offer it to the 282%. The moment he does not give it, you take him 5 lakhs from him. Then you give it to the next one. He doesn't give you, again
Another
take the 5 lakhs. Third one, 5 lakhs, and then give it to him. By that, I think you can get back what you lost.
Lordship.
And they also, my lord, incur expenses. They are collecting now, they incur so much of expenses.
It's okay. Okay.
My lord, I'll be.
We finish it off. If you're not there, no problem.
No, I'll be.
May not be satisfied with his argument, then we may dismiss it all.
No, I'll try to be here.
23.
What is this? BTC, non-payment.
Non-payment of contractual bill. My lord, may I peruse the last order, my lord?
What is the work?
My lord, regarding hired supply of generator and supply of construction material, my lord. The work order is here, my lord.
So you pay as per Tamsayali, Mr. Bhuya?
Yeah, ETC culturally.
So you do one thing, we pass an order, verify within 2 months,
Yes,
and then pay him as per Tamsayali?
yes, sir, that can be disposed of, please.
Chalo, disposed.
Much obliged, my lord.
Twenty-four.
Made with the lordship. Inspection is awaited, my lord. So allow me 2 weeks time to find my, get the instruction, find my application. This is also outstanding bill.
Eh?
This is also outstanding bill.
Part payment we have.
My goodness, how can there be an instruction awaited? After 4 months.
The instruction has not come, my lord. We have-
So next time onwards, because of you, we shall then say that, okay, no, making it notice and returnable within 1 week for non-payment due. And then blame it upon you whenever other councils oppose. That giving 4 months also makes no sense.
My lord,
Tell me.
still allow me to 2 weeks time, my lord. I will get that.
Not
But
2
you-
weeks. We have it the day after. We'll have it on 3rd.
My lord,
Get your instruction, whether he's entitled to that amount or not. Oh, okay, 7th.
Yeah.
As per you,
Lordship will let it be on 10th.
7th,
7th, I have some difficulty in
6th,
10th, my lord. 6th,
10th,
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 10th.
10th.
You get your instruction without fail.
I'm obliged.
Mr. Esbora, appearing on behalf of the GMC, submits that a final opportunity may be granted to the GMC to obtain the, to place on record the it stand by filing the affidavit to stop list this matter on 10th of November 2025. The affidavit be filed on or before 6th of November. I kept you my word as regards the 6th. On 6th of November 2025. So it is made clear that no affidavit is, if no affidavit is filed, this court shall presume that the respondents GMC has nothing to say in the matter.
I'm obliged. Same order in the next case.
Item number 25. My lord, same order may be passed, my lord. Because there also they are to file, my lord, the response on the same date. Your lordship had taken up the other matter also.
Let us see what is that.
Yes, my lord. 25, my lord.
Oh, same.
Same, my lord. I'm obliged, my lord.
I'll give you both time till for 6 months to make the payment. Once it is admitted, it is 6 months. I don't go by 1 month, 2 months, 3 months, 6 months.
Obliged, my lord.
Yes, Mr. Gupta.
So this is the letter dated 31 July.
Oh.
On the basis of which, my lord, they have come to a conclusion that, my lord, the tenderer cannot take extra load of work. Here, my lord, at serial number 161, my lord, the last 3 pages, my lord will take note. Serial number 161. The name of the petitioner is there, my lord, wherein he has been kept under the remark column, no. Whether considered capable of handling more load. Appendix B, my lord, page. Serial number 161. Total number of work in hand, my lord, is shown to be 181 crores. And the work completed is 37 crores only. So, my lord, there was, on the date of the submission of the bid, my lord, the petitioner was not performing their ongoing projects properly, my lord, and.
Slow progress.
Yes.
No, all these things are understood, but my question is here. Whether you can very well, if there is a slow progress, you can very well consider whatever it is. But if there is a slow progress, is that a ground for cancel?
Yes, my lord.
Holding it technically.
Page 88, my lord, cost 2.1.4. Page 88. 2.1.14.
Including any individuals, the unit should not be non-performing. Because included.
On the clause, my lord, 3. Fails to complete or has missed any milestone and progress not commensurate with contiguous unencumbered project length / row available, even after lapse of 6 months from respective project milestone, schedule completion date, unless the extension of time has been granted due to authorities default or force majeure. So in respect of and then one at page 90. The authority reserves the right to reject an otherwise eligible bidder.
Now, you have a right to reject, but you have got this information on 31/7.
Well,
This was an information given to you by whom?
Malad, it is from the headquarters, Malad, it is by the projects, based on the workload written submitted by the projects. Various projects are undergone, Malad, in various parts of the country. This contractor is participating in many other projects of the BRO.
The petitioner is doing some other progress.
Yes, Malad.
Where?
Malad, Malad will take, Malad, this first page, 31st July, the following. There are 3 lists, Malad, given based on the workload returns submitted by the projects. Consolidated workload return of contractors class SS, SAB and unlisted for quarter ending March 2025 for BRO is circulated herewith as under. List of enlisted contractors, list of unlisted contractors as per Appendix B, list of contractors whose contracts have been cancelled and there is outstanding recovery due against them. So under the second list, Malad, his name is there. And then following contractors having no remarks in the column 4. That is whether they are considering of capable of handling more load, shall not be permitted to participate in e-tendering in any formation of BRO till further orders. So his name was under this list, Malad, due to non-performance in other contracts. The clause clearly valid provides, Malad, as on the bid submission date, if he is a non-performing party, the authorities can reject the bid.
It has been issued by whom, this document?
It is by the Director of Contracts,
Of
the DGBR, Malad.
DGBR means?
Director General of Border Roads.
Okay, so this is a project of BRO,
BRO,
the present contract.
Malad.
Now the question is, that means you have blacklisted these people.
Not blacklisted, Malad. Blacklisted is third category. They have been not permitted to participate, Malad, due to their poor performance. In
Understood.
respect of
So here
undergoing-
it says, the following contractors firms having no remarks in column 4 shall not be permitted to participate in the e-tendering. Having no remarks in column 4 of WLR. What is WLR?
Workload return.
Shall not be permitted to participate in the e-tendering in any formation of BRO till further orders.
Yes,
So
Petitioner's name
it
is not
is
there.
based on 31/7.
Malad.
You have taken a decision not to permit him.
No, not to, he was permitted. His name is not there in this list, Malad.
Yes, it is there, na?
No, Malad, his name
Kindly
is
come
there.
kindly come to serial number 45.
Yes, Malad, I'm sorry. Yes.
So therefore, you have not permitted him. But tell me, if that be so, this document you have received on 31/7 or whatever may be, on 6, on 8/10, why did you hold him technically responsible?
So, Malad, after this, Malad, we have also asked from the contractor, Malad, by the communication, not asking him to disclose all the projects which he is been undertaking. That information was not disclosed by him.
Where?
Page 228, my lord.
Hmm?
Page 228. 228, my lord. While letter dated 26/9/2025. Certain informations were sought out, whether they have been blacklisted by the Ministry of Road Transport. And my lord, in column number B and C, they were required to submit details of their all ongoing projects, along with their updated status of any litigation, if any applicable. And then, my lord, further, whether there is any ongoing process of blacklisting under clause C.
And what is the reply to that?
Reply to that, my lord, is that
39.
page 231. My lord, they have said that the said information has not been submitted by the lead member as well as other members of the joint member, therefore, that information could not be provided. This communication, my lord, 31/7/25 is uploaded in the website of the ministry also for information to all.
So here he did not inform of all ongoing projects.
Hmm.
Because as per serial number B, you asked for the bidder is required to submit details of all their ongoing projects along with updated status of any litigation. He only stated that he has no litigation.
And no ongoing projects also. And no ongoing projects also. He has no knowledge of any ongoing projects.
No, he has not mentioned about any ongoing project.
Yes.
In
However,
fact, if you kindly come to page 231.
Hmm.
As regards clarification number B, I on behalf of do certify that we have nil number of litigation for any against any authorities here. Certified that nil. Now, these are okay, but your rejection is on the workload.
that is on the ground, clause 2.1.14, that is, my lord, that they are non-performing party as on date of the submission of the bid in respect of other projects which they are undertaking. As on the date of the submission of the bid, my lord, they ought not to have been a non-performing party as.
Or is it your submission
No, lord.
that taking into account that if they had mentioned about their ongoing project, the clarification which you have sought for,
Yes,
the fact that there is a slow progress by them would have come to light?
come to light, yeah. But we have to do it independently by seeking information from all the project formations. And we got that information that there is a poor progress. However, in
But
his
you
decision-
knew about this as on 31/7.
Yes,
So you knew it. Then why didn't you inform him that there is a mention of some slow progress?
but that requirement of informing, however, in his representation, my lord, he is giving clarification as to the delay. Page 313. This 31-7 letter was known to all, my lord. It was uploaded in the website of the ministry. All the contractors throughout the.
Here, kindly see, 261. This is the minutes of the meeting. Held on October under the chairmanship of the chief engineer. Shortfall as per appendix so and so submitted by the bidder, it has been declared the bidder has been barred by the Ministry of Air for implementing from participating in any bidding process for so and so. The bidder is required to submit details of all ongoing projects along with updated status of any litigation, if any, so and so. However, the same has not been submitted by the lead member as well as so and so. The bidder is required to submit details of any blacklisting. You say about that. Now kindly come to page 270. This is the basis on which you hold the bidder to be technically responsive. Submitted the detailed clarification along with submitted supporting documents.
That is regarding.
Details of it. So you feel as on this particular date, this meeting is when?
6th.
23rd August.
No, October.
6th October.
6th October. 6th October, you have found him to comply, although he did not say anything about the ongoing projects. Isn't it?
It is of August.
Kindly come to page 270.
270, my lord. This is-
270.
Yes, no, this is of August, my lord. It starts from page 254, the type copy. Tender evaluation for a tender carried out by the Technical National Committee on 23 August 2025.
Where do you find?
Page 254, my lord.
Page?
254.
This is held on October. Where do you say?
The type, this is the type.
No, on 23rd August it was, they started. Then you sought for clarification. You see, first portion, annexure 1. You see the first portion. These are screening committee's finding. And in response to these findings, which was happened in the month of August, you say that these are the things at 261. Isn't it?
No.
So in 261, you say these are the shortfalls.
Yes.
This resulted in you to issue that notice which you have referred to. And he replied.
Reply.
And in pursuance to the reply, at page 270, this is the comment.
Yes.
So you seem to be satisfied in spite of the fact that they have not mentioned that there is any ongoing project.
No.
In his reply, he has not mentioned about the ongoing project. But you say out there the bidder has submitted the detailed clarification along with supporting documents. Now, in view of that, you hold the petitioner to be technically responsive. Isn't it?
Yes.
Now, this is this. Now you bring out another issue on 8. And in 8, you say paragraph 5.
Yes.
The screening committee of Iman had examined the shortfall technical bid documents submitted by the bidders in conjunction with that, including the RPF and the supplementary technical evaluation proceedings dated so and so, which was conducted. Based on the document provided, the evaluator, the screening has carried out its technical. The findings of the are as under. So here again, you hold him to be technically responsive. This is the first one, re-evaluation. So this is final. So you have asked for recommended for financial bid opening in respect to the petitioner. This was on 8th of October, after 6th. Now you have gone for another one.
Supplementary manuals.
Yes. So you decided that without taking into consideration 31.7.
31.7 was taken into consideration.
Now, earlier you did not.
Earlier did not, my lord.
So now,
The supplementary.
if you see paragraph 3 at page 303,
Yes, my lord.
you say now that the workload return for the quarter ending March 2025 circulated by so and so at serial number 45 has been marked as no under the remark column for being considered capable of handling additional load. Now it is on the basis thereof you have now rejected.
Yes.
Okay.
Yes.
Now the question is whether the workload return is a condition in the contract.
Yes, my lord, that clause 2.1.4.
Huh? Clause 2.1.4 does not say,
2.1.4.
there is not a single whisper of the word
No.
workload limit. What is workload return?
Work, my lord, load return means, my lord, if any party has failed to achieve the milestone, if my lord takes page 88. Page 88, clause 2.1.4. The bidder, including an individual or any of its joint venture, should not be a non-performing party.
Non-performing is very good.
Yes.
As regards slow progress, you are taking action against him, it's okay. But you are taking on workload return.
That is a conclusion reached.
What do you mean by workload return? Is it mentioned anywhere in the RPF?
No, if someone fails to achieve the milestone, my lord.
That
given
is a case of slow progress.
No, no.
It's a case of slow progress. It's a case of non-performing.
Yes.
But that's not the reason for which you have issued the supplementary minutes. The supplementary minutes is on the basis of 31.7.
Yes.
So therefore, if it is on 31.7, which you ought to have taken into consideration, which you failed to take, you can take into consideration. But whether on account of workload return, is it a necessity in terms of the contract is what the submission is that of the petitioner?
Meaning of workload return is, my lord, since contract is
Mr.
already performing poor in respect to other
Gupta,
contracts.
See,
My lord, I am getting-
I have no expertise in construction.
My lord.
I don't know what is workload return. There is a circular or a notification issued that these people who do not have workload return should not be allowed to participate in any BRO. So in simple words, you are now saying that don't allow him to e-tender. On the basis of the communication, they did 31-7. Didn't it?
No.
And therefore you have now hold it because earlier it did not come to your attention that aspect. But now means although it was there, everything was there, but this thing did not come to your attention. Now having realized that, you have held him to be technically non-responsible.
Yes.
Unless and until 31-7 is set.
Yes.
You have bound.
Yes.
That's your submission.
Yes. 31-7 was communicated also.
That's his submission.
So far as the NIT is concerned, my lord.
NIT is okay, but the problem is something like this. Unless you challenge 31-7, how do I take care of it? There is a direction upon it's more like a blacklisting or whatever may be.
Lord, it's
There
blacklisting,
is a direction upon the BRO not to allow those persons to submit it. So without 31-7 held to be bad, they are bound by that. I would have understood if it is any other project, having NHI, DCL or anything. But the question remains in view of 31-7, you can't be allowed to participate. Have you looked into 31-7?
Yes. Just now, yes.
So don't you think that you need to challenge this? You see, the following contractors firm having no remark in column number 4 of WRR shall not be permitted to participate in tendering in any formation of BRO until further orders. So unless you challenge this, they have acted on the basis of this. Yes, initially they did not take into account, but subsequently they took into consideration that. But you need to challenge this document.
Yes, my lord. That is one aspect, my lord. But what I am, my lord, this has been issued on 31-7. By that time, my lord, bid duty is over. Technical evaluation committee has already scrutinized my documents. This has not come into picture, my lord. 31-7. Prior to that, my lord, in fact, the first meeting minute was, my lord.
In fact, Mr.
On
Saikia,
23/7/25.
Mr. Saikia, you have also not submitted the proper reply to what he asked in respect to 2.1.4. Because of the fact you were asked in clarification number B that what are your ongoing projects? You never said so. There are two aspects of clarification number B.
Everything started with the, my lord, annexure 1 to the appendix 1A, my lord. At page 122, my lord. It's in my comfortable. My lord, serial number 5D, down below. The following information shall be provided with regard to para 2.1.4 for each member of the joint venture. Has the bidder constituent of the joint venture has been barred by the Ministry of Road Transport or its implementing agencies for the work of Express, National Highway, ISC and EI.
This is pertaining to clarification A.
Yes, yes, I'll come to Lordship. This is A. So this is
And you have duly answered.
Yes.
Clarification A, you have duly answered.
Right.
Then look here. NHI, DCL, Government of Mizoram have blacklisted or debarred me, but the period is over before the due date.
Yes.
So this duly answers as regards Appendix 1A. No quarrel with that.
Right. That was the
But
clear.
what about clarification B?
My lord, for the moment, page 123, my lord, we take clause 8 also.
Clause?
Paragraph
A
8.
statement by each of the joint venture disclosing material non-performance or contractual non-compliance in past projects, constitution and bill, and in the last 2 years in a month in a given below attached extra sheet.
And here clause 3 is also the requirement. My lord.
Huh?
It's to complete. Name of the bidder and in this format, my lord, the information was sought to be given, fails to complete or has missed any milestone, progress not commensurate with the same exact clause which I have read, my lord, 2.
No, that is okay, but you asked for this, no? But Mr. Saikia, there is a problem, means they, unless you set aside this, there's a bar. Don't you think that you need to challenge it? We keep this matter, file another petition. Challenge is, you have to challenge it because this is the basis on which they have done. Because the word used is you cannot be allowed to participate.
My lord, had it been, my lord, prior to the, my lord, the NIT, etc., my lord, that is under, this is ongoing, and the effect is the slow progress. For slow progress, my lord, various, my lord, measures, my lord, once the contract agreement is entered into, there, my lord, extension, etc., my lord. all these
Therefore, the
things are there.
question is, if there is a slow progress, means there is an ongoing project.
No, ongoing project, everything has to be prescribed here, my
No,
lord.
no, no, no. If there is a slow progress, means there is an ongoing project.
Okay.
Otherwise, they would have said that they did not qualify. They did not complete
My lord, these
or
are,
completed later on.
my lord, these are all, my lord, these ongoing projects are all, my lord, submitted, my lord, as per clause 2.2.21. Because one has to evaluate, my lord, the bid capacity. So for bid capacity, the work I have already completed have to be mentioned. Then the ongoing works, even, my lord, where only LOI has been issued, then also that will be taken into ongoing project.
You have mentioned all those.
Yes, yes, my lord. For two, lordship, you can see, my lord, this page 93.
Yes.
Bid capacity, 2.2.21, bid capacity, bidder.
No, the bid capacity, I have understood.
No matter how it is, my lord, the ongoing project as well as, my lord, where LOA has been issued, but the work order has also not been issued, those will also be taken as an ongoing project, I have to mention. So thereby, my lord, the bid capacity is determined, a formula has been given, my lord. So everything is there, my lord. It is not that I have not, my lord, mentioned, my lord. It is there, my lord. Definitely, my lord, this clause B, my lord,
Now, then why they have asked you about this thing? If you have given everything.
my lord, they are, my lord, seeking with regard
And
to.
you have not answered to that.
No, I
Can
have
you see
answered,
that?
but my lord, they are asking whether any litigation is pending.
No,
Look,
can we see that?
No, my lord, the
Document?
wordings, my lord,
Where
yes,
is that document?
288,
Huh?
288, and my reply 30.
No, not that. Prior to that,
230, my lord,
230.
231, clarification B, 231.
And here you see 228.
220 is the
Listen.
so cause.
As per clause 2.1.4, para 2, serial number 1 of the RPF, the bidder is required to submit details of all ongoing projects along with updated status of litigation.
So basically the litigation, my lord. Because these are already these ongoing projects are there in the 2.2.1, my lord. So if any litigation is there, I have to submit them. And I have said there is no ongoing litigation.
So your therefore submission is, in short, 31.31.7 would not apply, taking into account that this is subsequent to your bid submission.
That is one submission.
This is only for a purpose where a person can be not permitted in e-tendering.
The requirement.
Subsequently, it may be, my lord, it may be incorporated that this circular.
What
will
was
be
the
at
last date for submission of the bid?
18/6/25.
So it was 18, as on 18/6, as on the last date, this document was not there.
Not there.
So you cannot apply this document for the purpose of holding you technically not responsible. That's
That is
just-
one.
Initially.
And secondly, even if it is, my lord, held to be, my lord, applicable, then also, since, my lord, this amounts to blacklisting, my lord, they should have, my lord, asked me a so cause, my lord, as to why this slow.
But Mr. Sriker, that is not a subject matter of challenge.
My lord,
31.7 is not a subject matter of challenge.
that is there, my lord. That is there.
You have not challenged.
Lordship, my lord, because this was never, my lord, I don't know, they said, my lord, that it is uploaded, but even their own, my lord, till October, they have not referred to it, my lord, even we did not find it, my lord.
In fact, they also didn't know.
Didn't know, my lord. So now, on 8th, my lord, they held me responsive, my lord, the responsive, and the 9th, they sit only for this purpose to oust me. That is one thing, my lord. They should have asked me at least a so cause, whether my that slow progress is.
But on the
They are not, my lord.
one humble submission, Lord. on
You have
the-
not awarded the contract?
No.
Don't ever.
But on the date of the submission of the bid, my lord, he was, my lord, a non-conforming party. In 2.1.14, my lord.
See, Mr.
My lord, those three,
Non-performing party is not the issue on which you have rejected him.
that is the issue. If my
No.
lord- If my lord will again take.
No,
reject
no,
it,
Mr. Gupta, you have rejected him on the basis of 31-7. On the
Yes,
ground of
31-7.
workload return. I think you need to explain by way of an affidavit.
31-7, my lord, was communicated. It is uploaded on the website to all the contractors. It is known to
If
him.
it is so,
And
then
it was
why
not
on,
paid.
no,
Not
Mr.
paid.
Gupta, if that be so, that is why on earth you did not look into it on 6th or 8th? Why?
That is why the supplementary, my lord, meeting was held. And it
Definitely.
reviewed all
Therefore,
the meetings.
therefore, the question is, why didn't you look into it earlier? He says 31-7 cannot bar him taking it. Yes, maybe a bar, but that bar will only operate prospective. I have already submitted my bid on 18-6.
Yes, and as on date, as on that date, that bid is.
Mr. Gupta, Mr. Gupta is
violation
not
of
allowing
2.2.4.
allowing his repetition today.
Hmm.
You file your short affidavit on this page as regard 31-7.
But I
Be-
pray no stay, my lord, because prima facie, there is a violation of 2.1.14. They have been.
But that is not the reason for why you have not granted.
But the-
Well, show me a letter, a word out here that on the ground of 2.1.1.4, you have rejected. You were duly satisfied on the meeting of 8, say 6 as well as on 8.
My lord, the meaning of capable of not handling additional workload means. that
Where?
only. If-
Where is it mentioned? Where?
My lord, my lord, page 323.
Of
They have filed an additional affidavit where this is the bid document. Bid submission document which they have submitted,
323.
323.
That
In that, my lord, paragraph 8, this statement has to be made in terms of
is to
2.1.4.
fulfill its obligation to maintain a highway in a satisfactory condition.
323, my lord, three,
323 then?
this is the additional affidavit filed.
Yeah, where?
Paragraph, clause 8, a statement by the bidder and each of the members of its joint venture disclosing material non-performance or contractual non-compliance in past project, contractual disputes, litigations, arbitrations in last 2 years is given below.
No, it's
This
okay.
is in terms of.
No, Mr. Gupta, I understand everything. Here he has said nay. But
Yes.
my question is, in your additional supplementary screening committee meeting,
No.
where have you held that there is a non-compliance 2.1.4? Where? Show me that.
That will be part of internal record, my lord.
So
that I can take it.
record is,
But
you
my
see,
submission is, my lord,
no,
not capable of handling additional
Mr.
load. It may-
Mr. Gupta, this court is otherwise not interested in permitting the petitioner to participate, taking into account his track record.
My lord.
His track record seems to be very bad, poor. But that is not the decision of this court.
No.
This court's decision is as to whether you have taken into action by following the mandate of law. If your decision is on the basis of the WLR,
It's on the basis of the
WLR, and this WLR springs from 31-7,
Yes, my lord.
and this
it has
this WLR has no reference to the RPF.
It has reference, my lord, although that exact
So-
word is not there.
So,
Exact
so,
word is
so,
not
so
there.
therefore, you need to be more
Because, my lord,
clear.
90 is part of.
Okay,
clause
okay, enough.
2.1.
I've heard a lot. This should be finally disposed of. I think we need to state something.
My lord, already.
So much hearing. Okay, you should notice. What?
Bid has been opened, my lord, and.
So don't give it.
You know,
We have a short date. How fast can you file it? Mr. Gupta, I'm telling you, I have nothing to do.
No.
As regards the petitioner, his actions have been totally unsatisfactory. He have not been able to perform many work.
No,
In fact, I think he had just come out from debarment
yes.
in one of the the NHIGCL project,
Mm.
where he was last debarred in the year 2023
Mm.
and it ended in 2024. So all these things I've understood. He has not been able to do anything. But the thing is, we need to stay this till the next date. Short. When can you file?
Lord, 7 days, 10 days.
Hmm? And how many bidders were there?
Total 14 were found to be responsible.
And why you have not made the other bidders a party?
My lord.
Bidders.
Isn't it the law as per AFCONS?
But because it is.
Isn't that the law
We are not.
of AFCONS, paragraph 22? Isn't it? 2016 10 SCC.
I ought to have met, but my lord,
Then
primarily
if you have
it is-
not make them a party,
I am my lord, lordship.
because tomorrow
Right.
these people are going to be affected. Their bids have been opened. Everything has been opened.
I'll add them, my lord. I'll add them, my lord. Okay.
You'll add them means how do I? Anyway,
I'll add them, my lord.
issue notice making it returnable. When can you file it? 10th of November? Just sort of it on only on that basis. I'll pinpoint it. What is the issue? Huh? Issue notice making it returnable on 10th of November 2025. Mr. H. Gupta accepts notice on behalf of all the respondents. Extra copies of the writ petition be furnished upon him along with the additional affidavit during the course of the day. The case of the petitioner herein is that the petitioner is aggrieved by the actions on the part of the respondent authorities in rejecting the technical bid of the petitioner. Subsequently, on
9/10/2020.
on 9/10/2025, on the basis of a consideration, on the basis of certain materials, which were not part of the tender conditions. Mr. P.J. Soike, the learned senior counsel, appearing on behalf of the petitioner, submitted that in pursuance to the notice inviting tender, the petitioner submitted the bid on 18/6/2025. Initially, there were certain findings given by the screening committee. And based upon such findings, the petitioner was issued a notice seeking certain clarifications. Issued notice on 26/9/2025 seeking clarifications. In response to the said notice, the petitioner submitted the clarification dated 30/9/2025. Referring to the first minutes of the meeting held on 6th of October 2025, the learned senior counsel submitted that the tendering authority were duly satisfied with the tender, with the technical competence of the petitioner, and had come to an opinion that the petitioner was technically competent, responsive. The learned counsel, senior counsel further submitted that this particular opinion of the of the tendering authority was further confirmed in the second minutes of the meeting held on 8th of October 2025. The Learned Senior Counsel submitted that subsequently, all of a sudden on 9th of October 2025, the petitioner was held to be technically not responsive on the basis of a communication dated 31/7/2025, which, however, was not even provided to the petitioner. He further submitted that the basis on which he submitted that the communication dated 31/7/2025 could not have been taken into consideration in as much as for the purpose of the instant could not have been taken into consideration for the purpose of the instant tender, in as much as the last date for submission of the bid was prior to 31/7/2025. In addition to that, the Learned Counsel submitted that the Learned Senior Counsel submitted that the criteria on the basis of which the petitioner have been held to be technically not responsive is not a term and is not a part of the terms and conditions of the notice inviting tender. To sum up, the Learned Senior Counsel submitted that the respondent authorities, in order to fulfill their vested interest, have disbarred the petitioner, thereby including a term which is not a part of the terms and conditions of the notice inviting tender, and thereby such act on the part of the respondent authorities to do so amounts to arbitrariness and in violation to Article 14 of the Constitution. Per contra, Mr. H. Gupta, appearing on behalf of the petitioner, a respondent, submitted that this is a case where the petitioner have not disclosed various aspects. He has not fulfilled, the petitioner have failed to comply with clause 2.1.4, 2.1.14 of the notice of the instruction to the bidders, inasmuch as the petitioner have not provided the necessary details as regards to the which would otherwise show that the petitioner is a non-performing entity. Full stop. This court, upon hearing, this court heard the Learned Counsels appearing on behalf of the parties on the question of issuance of an interim order. Mr. H. Gupta, the Learned Counsel, submitted that pursuant to the notice inviting pursuant to the technical evaluation being carried out, the financial bid have already been opened and steps are being taken for the purpose of granting the contract.
L1 has been, yes.
Granting the contract. He further submitted that if there is a delay in granting of the contract, it would lead to escalation. And as such, the public interest would be affected. So this court have duly heard the Learned Counsels on the aspect of the interim prayer and is of the opinion and it is this court and have also perused the materials on record. From the perusal of the materials on record, it is seen that in the minutes of the meeting of the technical committee held on 6th of October as well as on 8th of October, the technical committee have duly taken note of all the materials and come to a conclusion that the petitioner, along with some other bidders, were technically responsive. However, while doing so, it appears that the respondent authorities failed to take into consideration the communication dated 31/7/2025, which was taken up in the supplementary meeting held on 9th of October 2025. It is further pertinent to mention that the basis on further pertinent to mention that the reason for which this court the question as to whether the question as to whether the communication dated 31/7/2025 could have been at all taken into consideration can be ascertained upon the response from the respondents being made available. More particularly, when and as to whether, more particularly, and where response made available before being placed before this court, and further to that, as to whether workload return is a term of the contract. This court is further aware that granting a stay under such circumstances, it is therefore the opinion of this court. This court is also aware that if there is no stay granted till the next date, the instant writ petition would become infructuous and would also lead to third-party rights. Considering the above, this court, therefore, directs the respondent authorities not to issue any work order or enter into a contract with any other bidder, in respect to the contract in question till the next date. First, the respondents are directed to are given the liberty to bring on record their stand by filing the affidavit by 7th of November 2025. The further continuation of the interim order would be taken up on the next date. I have not mentioned anything about FCONs, but I hope you really take note of. And Mr. Gupta, you duly inform the people, because later on they should not come up and say, oh, Mr. Gupta did not inform, they did not cover. Tatata line likhi dibo. Mr. Gupta shall duly intimate the respondents via telephonic communication, duly inform forthwith that the order so passed today. A copy of this order be furnished to him during the course of the day.
Item 26 to 28 for admission.
Oh, this matter.
We had submitted an initial affidavit to take copy of the judgment, which shows that BTC has either accepted banked up. Either BTC has accepted banked up, submitted by the tender in the name of the other person. Here the case is the same. So we have submitted the earlier judgment by this affidavit. The Lordship will kindly see from para 8 of the judgment.
You gave the bank draft in the name of somebody else.
Yes.
Hello?
That's the question, interpretation of 5 and 8A of the law. For with regard to additional affidavit that has been filed, my lord. Ultimately, my lord, because of the public interest and also this writ petition was dismissed.
Huh?
Dispute I have filed challenging on that point, that the bank draft submitted by another person should not be accepted. Challenging that I have filed this affidavit, but my plea was rejected. The court has held that the other person can can be accepted. I was the petitioner, because I have challenged the settlement of the another person who has submitted bank draft
In somebody else's name.
in the name of another person, my lord.
Then
But then the court held that this, yes, other person can file it. It can be
is the
accepted.
order, where is that?
BT.
Order.
Order another additional affidavit, the
Corona, yeah, teacher.
page, annex 4 of the judgment. Your lordship kindly see from para 7. So para 8 of the judgment, 8 or 8 thereafter, dealing with this point.
It will be more specific.
So this court permitted. This court permitted.
Ultimately, the writ petition was dismissed.
This is,
If
I
the
have filed.
petition was
challenging
dismissed,
it.
questioning
Yeah.
that a reading of AI cannot be
Yeah.
in the name of AI, so it can be given because that was held to be not a term,
Yes.
that it has to be in the name of it.
Absolutely.
And so therefore, these writ petitions needs to be allowed.
What I am on, my lord,
Yeah.
that is subject matter before this honorable. Paragraph 15, my lord, wherein the Supreme Court judgment has been cited, my lord.
Paragraph
In the decision-making process, with the power of review to go to that extent with regard to my lord, rejection or accepting this one, two judgments were preferred, my lord. Between two, there must be a very careful to see if there is an element of public interest involved in the litigation. They also oppose that in better or certain commercial transaction.
These are okay. These
Yeah.
are okay. I'm not on that. But the fact remains that these observations which is being made out
Yes,
here
that's true.
at paragraph 13
Yeah,
of the judgment at page 62
yes.
makes it abundant and clear that the
It's
question
not
as
required.
regards having a must necessarily deposit the offered by him in the market in the former in favor of the Iman along with the Iman. If any bidder did not submit the bank draft along with them, the sale. In the case when the bank draft was Iman and yeah, it is not a specific condition in clause 5 read with so and so of the that the purchaser of so and so must be the bidder himself. From a look at the demand draft dated deposited, it is seen that the demand draft was purchased by so and so. They asserted by the respondent number 7 in the counter affidavit that Hazir is his employee, and it was the instruction of the respondent number 7 purchased the demand draft, is not a party respondent in the instant proceedings. But now tell me whether the demand draft is still valid.
Yes, it is very nice.
But we are not going to, we have to set aside that.
My lord, let them face, my lord, decide.
It will have, you have a fresh tender.
Absolutely. That can be done.
Not fresh tender.
Yes, when the bank draft can, when the bank draft can be accepted.
Huh?
As the BTC
How
has
can your
accepted the
bid
bank
be
draft, this should
accepted?
also be accepted and settlement should be made in the name of the petitioner, my lord. He is the highest bidder.
So again bid, give a higher bid. Next time don't make that mistake. All these three repetitions are same, na?
Yes,
There's
yes.
no interim
Same.
orders passed.
So we are filing.
My lord,
We set aside yours. You are appearing for?
Number 26.
Ah.
Number 4.
What do you have to say?
Number 6. Number 6.
You got the tender
Yes.
at a lesser amount. We set aside that.
Yes.
And allow them to go ahead with a fresh one.
Fresh.
And you again participate.
Yes.
Okay. Heard Mr. K. Sharma, the learned counsel appearing on behalf of the petitioner. Mr. A.K. Bhuya appears on behalf of the BTC. The learned standing counsel appears on behalf of the BTC. And Mr. S. So-and-so appears on behalf of one of the private respondents. You are also appearing? All of you are appearing for private respondents? Okay, give your names. Who is appearing in which appears for the response? The issue in the three writ petitions are similar, and as such, all the three writ petitions are taken up for disposal by this common order. The issue which is involved is as to whether a bank draft submitted as the amount tendered in the name which is issued favoring the Secretary BTC, Principal Secretary BTC, as to whether the bank draft issued
No, Principal Secretary BTC, bank draft issued it in name of the Principal Secretary BTC.
in the name of the Principal Secretary BTC, purchased by a bank draft submitted by a tender bidder in the name of the principal favoring the Principal Secretary BTC, purchased by another person for and on behalf of the bidder, could have been taken into account and can be a valid tender of the bank draft.
Right.
Of the valid tender of the offered rate. Full stop. In the instant case, no full stop. The facts as would arise from the instant case in the three writ petitions are that only. In WPC number 4752/2025, it relates to a notice inviting tender dated 7/5/2025 for settlement of what? Settlement of in all are same tender notice, na?
Yes. Dumni.
All these are same tender notice,
Same tender.
except the
Same tender.
markets are different.
Yeah, but
In all the three writ petition relates to tender notice dated 7/5/2025 for settlement of markets /go-hats /parking /parghat ferry cattle pounds etc. for the year 2025-26 issued by the Block Development Officer, Baksa Development Block, Musalpur. In WPC number 4752/2025, The market in question is the Dumni Daily Market. Isn't it?
Five, city number five.
Dumni.
Yes.
Full stop. In WPC number 4753/2025, the market in question is Bari Makka Open Market. And in WPC number 4804/2025, the market in question
Borbari by.
is the Borbari Bi-Weekly Market. Admittedly, the petitioner herein bid is petitioner, who is the writ petitioner in all the three writ petitions, bids as against these markets were higher than that of the bids submitted by the respondent, by the private respondent. However, the markets in question have been settled with the private respondents. Resultantly, the petitioner being aggrieved has approached this court. First, on the earlier occasion when the matter was taken up, the counsel appearing on behalf of the BTC had submitted that on the ground that the bank drafts were submitted by the petitioner as the offered rate was not a bank draft which was purchased by the petitioner. And as such, the said bank draft could not have been taken into consideration. Also, the issue therefore arises as regards the interpretation as regards clause 5 and 8A of the tender notice dated 7/5/2022. It is seen that the said issue is no longer res intriga in view of the judgment passed by the learned coordinate bench in the case of Corona Deuri versus State of Assam, bracket, WPC number 7889/2022, dated 21/4/2023, wherein the learned coordinate bench had opined that it is not a specific condition in clause 5 read with clause 8A of the tender notice that the purchaser of such bank draft must be the bidder himself. This court therefore finds it pertinent to quote paragraphs 12, 13, and 14 of the said judgment. Next. In view of the law well settled by the learned coordinate bench of this court, which this court duly endorses, the rejection of the bid of the petitioner in all the three, in respect to all the three markets, which is the subject matter of the three writ petitions, appears to be not in consonance with law, more particularly when the petitioner in respect to all the three markets had offered a much higher rate than that of the private respondent. Considering the above, the three writ petition stands disposed of with the following observations and directions. A. The approval given by the CHD, Markets and Fairs, Boroland Territorial Council, dated 15/7/2025, in favor of the respondent number 6, in WPC number 4752/2025, pertaining to the Dhumni daily market, is set aside and quashed. The consequential allotment letter, settlement so made, settlement order passed pursuant to the approval in favor of the respondent number 6 in respect to the Dhumni market, Dhumni daily market, since set aside and quashed. Daily, weekly market day, daily, weekly market, huh? And the weekly market hole beleg hobe, daily, weekly market. But the approval so granted by the block development officer Tihu Boroma Development Block, thereby settling the Borimaka open market in favor of the respondent number 6 in WPC number 4753/2025 is set aside and quashed. The consequential settlement order so made in respect to Borimaka open market in favor of the respondent number 6 in WPC number so and so is set aside and quashed. Number 3. This is which market?
Borbari by Atli.
Borbari.
Borbari by Atli.
This is Borbari bi-weekly, na? The approval dated 15/7/2025 issued by the CHD, Fairs and Markets and Fairs, Boroland Territorial Council of the Borbari bi-weekly market in favor of the respondent number 6 is set aside and quashed. Respondent number 6 in WPC number 4804/2025 is set aside and quashed. The consequential settlement order on the basis of the approval dated 15/7/2025 in respect to Borbari bi-weekly market in favor of the respondent number 6 is set aside and quashed. Next, number 4. The respondents herein, the respondents in the BTC are directed to take effective steps if so advised for settlement of these markets in accordance with law. What? You have been running.
No.
Yes?
They have a claim there.
One was stayed, but other two, there was no stay. So it shall be open to the respondent, private respondents whose settlement have been quashed to approach the concerned BTC authorities for remission of the amount so far as the unused remission of the amount for refund of the offered rate if offered rate. The BTC authorities shall duly consider the same in accordance with.
Well, in this case, I'm appearing for respondent 1 and 3. I have received an instruction from the respondent 1 yesterday. But they have said that the leverage, we have also filed an affidavit to that effect, and they have requested for some time. Better relating to payment.
Well, either the requisition was filed for non-payment of the professional dues to the prisoner case for the services rendered as standing counsel of NRCP.
This is pertaining to
Non-payment of professional dues, my lord. Professional dues, my lord, for the services rendered as standing counsel of NRCP.
where is the direction?
My lord, at page number 9, my lord. The order dated 8/5/2024 starts at page 9, my lord.
Have you filed your affidavit?
For respondent number 1, I have filed an affidavit indicating that steps have been taken. The matter is under process. And a further instruction I have received yesterday that I have received. What you can grant us some time. Let me have the further instruction.
What is the direction passed by this court?
The lordship may kindly come to page number 60 of the page 60. After noting down the amount payable, the lordship has said that due amount is ₹1,64,52,100. And this amount is the lordship has directed to
Within 3 months, my lord.
finally page 18. Para 23.
There are
22.
Para 20 onwards, 22 is the direction.
So this 1,64 has been directed to be paid.
Lordship. Correct.
Then
But I'm told the engagement of the council at that point of time was not a normal procedure. There are when examining the record for the matters have to be clarified. That is how it is understanding some time.
no appeal filed.
Appeal at this stage, till the not filed.
Well, so what do you want now?
But I prefer 4 weeks time, they have,
Or
they said, kindly help by later. They said that the matter is currently under process in this department. On 22nd, the deputy secretary has written.
no, the amount has been quantified.
Lordship.
Order passed in the year 2024.
my lord.
Then
No, the Lordship knows, but while processing the matter for payment.
unless and until you show me that judgment of Justice Gawai and Justice Mash, that delay does not amount to contempt, I can't help you.
But,
I can't give you further more indication. There's a judgment. Have a look. Recent. There's Chief Justice Gawai and Justice Mash. Mr. D. Nath, appearing on behalf of the respondent number 1, 2, and 3.
1 and 3.
1 and
You, my friends.
6 for some more time for filing. 6 for some more time, taking into account that the payment pertaining to for the some more time for effecting necessary compliance to the order passed by this court. List this matter again on 1st of December 2025 for an update. In the meantime, the respondents, the respondent number 2 and 3 shall bring on record their stand by filing themselves.
Hello.
Where is Mr. I. Botnakur?
Impugned at page number 13.
What is this matter pertaining?
What's impugned at page number 13? Relevant portion is page number 15, para 5, lordship. Issuance of IMFL of license lawsuit.
Have they taken a decision or no decision? What is the affidavit file? What do they say?
Affidavit is filed, lordship.
What do they say?
They have stated in para 6, lordship, of affidavit.
Our affidavit is on record, madam. In the affidavit, we have said that the application will be processed as per the new 114A amendment.
So you are processing it?
Yes.
Mr. I. Botnakur, appearing on behalf of the respondent submits that taking into account the directions so passed by this court in the order dated 8/1/2025 in WPC number 6920/2024. The applications of the respondents of the petitioners herein are being considered in terms with the notification dated 37/2025, in terms with rule na section
Rule 114 there.
rule 114A of the Assam Excise Rules 2016 as notified by the notification dated 9/37/2025. Was taking into account the above, this court therefore drops the instant contempt proceeding. However, grants liberty to the petitioner to approach this court if dissatisfied with this actions so taken by the respondents by filing writ petition, not by contempt.
Item 35.
Net vigilance. My lord, matter pertains to non-payment of the admitted amount of contractual bill.
We have not taken steps.
Yes, taken step, my lord, as per the Lazima order, my lord, the notice served, my lord, notice complete.
Service complete.
Yes, your lord.
Service being complete leaves the matter for admission on 17th of November.
Oblige, your lord.
You file your affidavits.
One small page,
The respondents shall bring on record their stand by filing their
one small page, if they may provide us a copy of
the writ petition.
Oblige.
36.
Oh, yes. Somebody has some problem, nah?
Service is not complete. Fine. But, police only get it. This 46 only get it. Private service.
Was 4 and 6 is incomplete. Who is 4 and 6? 4 to 6?
We have taken steps by speed post, my lord.
How do you affect service about 4 to 6? You've taken steps by registered post, na?
My lord, speed post, my lord has passed an order to send it through the speed post, my lord.
You've taken by speed post.
Yes, my lord. As per the order, my lord, we have taken steps by speed post.
Speed post. You must be having that track consignment.
My lord. My lord, I have.
And has it been served as per the year?
What track, my lord, track?
Find it out.
I have not checked it, my lord, I'm sorry.
Find it out. We adjourn the matter today, taking into account the difficulties faced by them. We'll have it when? When?
Next week.
Next week. It appears from the Office note that the service upon the respondent number 4, 5, and 6 is not complete. Mr. S.S. Goswami, appearing on behalf of the petitioner, submits that few steps have been taken by way of speed first. And he would ascertain from the track consignment as to whether the service has been effected and bring it to the notice of the court. Ms. So-and-so submits that the affidavit has been already been filed on behalf of the respondent.
Yes, my lord. We have,
And the petitioner, and it is also seen that the petitioner has filed the reply. It is also submitted that on account of Mr. B. Chaudhary, who is the standing counsel of the agriculture, being not present on account of personal difficulties, the matter be taken up next week. Taking into account the above, is the matter on 31st of October 2025, on which date this court shall consider as to whether there is any requirement for passing any interim directions.
37.
In the last, by the last order, your lordship had directed the petitioner to take dusty service on the private respondent, your lordship.
So, please, your lord, I have filed it affidavit today, my lord. I have already filed. Kindly take the matter Monday or Tuesday, my lord.
On Tuesday, your lordship.
Wednesday. Wednesday is closed, open.
Yes.
Monday, your lordship. In that case, Monday, your lordship.
No man, not possible. Closed. Wednesday.
Lordship, the service may be deemed to be complete, my lord. We have filed the
File the
affidavit.
affidavit of dusty, na?
Yes, your lordship.
Service complete upon respond number 5.
Yes, your lordship.
An affidavit of dusty has been filed. Affidavit of service has been filed.
1410
Insofar as the respondent number 5 is concerned. And from a perusal thereof, it appears. Who is the respondent number 5? Name?
Pushpa's Construction Private Limited. Your
Huh?
Pushpa's Construction Private Limited.
And who is Prakash Sharma?
Lordship, the receptionist who was there, your lordship.
Affidavit of service have been filed wherein it's been stated that the respondent number 5 have been duly effected service on 14/10/2025. And the same have been received by one Mr. Prakash Sharma on behalf of the respondent number 5. Taking into account the above, the service upon the respondent number 5 is deemed to be complete. Listed in the Ms. A. Gayan, the learned counsel appearing on behalf of the respondents of the authorities submit that the affidavit in opposition has been filed
Today, my lord.
today. To list the matter on 29th of October 2025 for admission along with and the registry shall bring on record the affidavit filed with response.
Deeply obliged.
For hearing item 31.
Hearing filed. Oh, yes, anything, any development?
No, the latest development, I have been informed that the final draft is about to, they are about to place before the cabinet.
Huh?
They are about to place the final draft before the cabinet for approval. It will be placed shortly when it will be placed.
Okay. Mr. D. Nath, the learned senior government advocate, submits that the final draft of the Assam Industrial Employment Standing Orders Amendment Rules 2024. 25
Written instruction.
is to be submitted before the cabinet in short time. List the matter on 1st of December 2025 for an update.
Fine, you can.
So, now Mr. Piridas, you are here.
my lord,
You are here.
I'm here, my lord. I'm required to go outside.
Huh?
I'm required to go out of Assam, okay, out of Guwahati.
Same is here. I am also supposed to go out of Guwahati. So should we take it some other day? Eh? Heard Mr. P.D. Das, the Lilly Senior Counsel, assisted by so-and-so, appearing on behalf of the petitioner. And Mr. T. Thousand, who appears on behalf of the respondent numbers 1, 3, and 4.
All the respondent.
Four. The petitioner herein is aggrieved by the cancellation of the tender process and issuance of a short notice inviting tender dated 22/4/2024. For settling of the Dhitokchara vehicle gate.
For the period 6/5/25.
For the period from
25 to
12/4/2025 to 31/12/2025. The material facts as arises from the, as could be seen from the records, is that a notice inviting tender was issued by the Executive Committee, Dimahasau, by the Secretary Executive Committee, Dimahasau Autonomous Council. He appears for Dimahasau. They Standing Council appears on behalf, who is the Standing Council of Dimahasau Autonomous.
NC Hills.
NC Hills. NC Hills, you are still NC Hills.
Name of the district has changed, but the name of the council is same.
But why is it mentioned as Dimahasau Autonomous Council in your tender notice?
It's not a documents, it has been mentioned as the Mass Autonomous Council, but
Kindly come to page 30 of the writ petition.
district council. Sometimes they are using the Mass Autonomous Council in some documents and in some documents as.
Issued by the Dimahasau Autonomous Council for settling of two vehicle gates, namely Moderdisa and Dito Chara vehicle gates. With the bid value stated therein. In terms with the said notice, tender notice, in respect to Moderdisa vehicle gate, the bid value has been put at rupees 75,37,500. And in respect to Ditoksara vehicle gate, it is rupees 75 lakhs. Pursuant to the said notice inviting tender, various bidders participated.
Page 132.
As many as 10 bidders participated. And from the comparative statement of 10 bidders participated in respect to the Tokchara vehicle gate. Out of these 10 bidders, 5 bidders were found to be technically found to be eligible. Justo. The 5 bidders who were found to be eligible were Sri Siddhartha Hojai, Des, where number 1, serial number 1, 2, 3, 5, table come 1, name of the bidder, and if I have value of tender. Sri Siddhartha Hojai, rupees 2 crores 87 lakhs 50,200. Sri Martoni, Martony, Rupsi, Rupsi, rupees 182,00630. Number 3, Sri THAIRINGDAO, Langthasa, rupees 157,20820. Sri Monichand Hojai, rupees 143. Monichand Hojai pisot tolot likhi dibo the petitioner. Rupees 143,00900. And Sri Joydes Ponglo, PHONGLO, rupees 132,32,000. First. However, on 17/5/2025, the respondent authorities took a decision to go for retender on the ground that the official rate of Detoxera vehicle gate is rupees 75 lakhs, which is very minimal of rupees 1 crore, for which tender process should be done immediately by cancelling the tender. It is under such circumstances the petitioner has approached this court by filing the present petition. Yeah, itu dia. Yeah. Cancel it. That's what Kali. In addition to that, the respondents have issued a fresh notice inviting tender, short notice inviting tender dated
22/4/25.
Where is that?
Page 34.
Page 34.
Yes.
Dated 22/4/2025 for settlement of the Detoxera vehicle gate for the period from 6/5/2025 to 31/12/2025, thereby putting the bid value, official value at rupees 1 crore. It is under such circumstances the petitioner had approached this court by filing the present petition. The record reveals that this court, by an order dated 1/5/2025, issued notice and stayed the short tender notice dated 22/4/2025, issued on 25/4/2025, was the interim order thereupon have been continued from time to time. You have not filed affidavit, na?
We filed it. Page 47, it's out from page 47.
It is seen that the page,
Page from 47 also.
huh?
From 47.
37. It is seen that the respondent numbers 1 to 4 have filed an affidavit in opposition. Wherein it has been mentioned at paragraph number 4 that the Mother Disa vehicle case was settled at rupees 5 crores 70 lakhs, 70,000. By settlement order dated 2/5/2025. And therefore there was no reason to settle the Detoxera vehicle gate at rupees 2 crores 87 lakhs 50,000, which is the rate offered by the highest bidder in respect to Detoxera vehicle gate. It was further mentioned that in order to get more revenue, the tender process was cancelled insofar as Detoxera vehicle gate, and there was a decision to retender the same for a period from 6/5/2025 to 31/12/2025, and the official minimum bid value was put at rupees 1 crore. Reply thereagainst have also been filed. To the present proceedings, to the said affidavit. When the matter was listed before this court on 15/10/2025, this court heard both the counsels and further inquired with Mr. D. Thousen, the learned counsel appearing on behalf of the respondent authorities, as to who is presently running the vehicle gate, the Detoxera vehicle gate, in view of the stay being granted by this court. It was submitted by Mr. D. Thousen, the learned counsel, that it is being run by the respondent authorities on their own. It was further submitted that in order to get better revenue as that of the Mother Disa vehicle gate, the decision was taken to cancel the tender process in respect to Detoxera vehicle gate and go for fresh tender. Under such circumstances, this court, taking into account that on the ground of getting enhanced, an increase in revenue, on the ground that taking into account the above, as it was the stand of the respondent authorities that to get a higher rate, to a higher amount, a decision was taken for going for retender. This court inquired with the learned counsel appearing standing counsel of the respondent authority as to how much the respondent authorities have earned during the period from the month of May till 15/10/2025, and the same be placed before this court. Accordingly, Mr. D. Thousan today have placed before this court an instruction issued by the Secretary Executive Committee, NC Hills Autonomous Council, which is kept on record and marked with the letter X. From the perusal of the statement and the revenue which have been earned, it is seen that for the period from month of May to October 2025, to 15th October 2025, the total revenue earned is rupees 71,68,200. Under such circumstances, this court have duly heard the learned counsels appearing on behalf of the parties on the basis of the above materials. From the materials on record as well as the submissions, it appears that when the notice inviting tender dated 26/3/2025,
Yes.
categorically had mentioned the bid value at rupees 75 lakhs. And when bids have been obtained far in excess, the reasons so assigned for cancellation on the ground that in another case the respondent authorities have settled at a higher rate does not appear to be reasonable, but rather arbitrary. More so, taking into account that from the collections so made by the respondent authorities by themselves from the month of May till 15th of October 2025 shows that the total amount collected is only rupees 71,68,200, and the remaining period as on date, and the remaining period for which it is to be collected is only would be another 2.5 months.
2 months. More or less
No, this is given till 15th October, na? No, I am not saying now. As the last date for collection of the rent, collection would be on 31/12/2025. Accordingly, this court therefore interferes with the decision of the respondent authorities dated 17/4/2025 for cancelling the tender process in respect initiated on the basis of the notice inviting tender dated 26/3/2025.
By an order dated 19/4/25. Cancellation order has been issued separately, madam.
Oh.
19/4/25.
Yeah, by order dated 19/4/2025. And further, the retender notice dated 25, 20, 24,
4/25.
24/4/2025.
22.
So accordingly, the writ petition stands disposed of with the following observations and directions. The cancellation of the notice in tender process initiated by the notice inviting tender dated 26, na?
22/4/25.
No, initial, first one, 26.
Initial is 26.
26/3/2025. By the cancellation order dated 19/4/2025 is set aside and quashed. Number two, the retender notice so issued dated 22/4/2025, 22/4/25 is further set aside and quashed. Number three, the respondents are given the liberty to grant the contract, to grant the settlement for the remaining period up till 31/12/2025 to the eligible bidders as per the in accordance with law.
This they will do within a stipulated time.
I'm giving them the liberty, they will do it.
Lordship will do it.
Huh?
Will do it at the earliest.
Mr. D. Thousands, the learned counsel submits that the same would be done within a period of 10 days. I'll record it.
Lordship, 2 weeks, Lordship. 2 weeks, within 2 weeks, we will do it.
Within 2 weeks. Because the more you delay, the more you lose.
We'll discuss.
Because now comparatively, you will get a higher revenue.
Lordship.
Within 2 weeks.
All right.